Court's now in session. The Honorable Judge Murphy presiding. Good morning, Your Honor.
Good morning, Your Honor.
Good morning, everyone. You may be seated. For purposes of the record, we are here today to continue the trial in the matter of State of Connecticut versus Raul Valle. At this point in time, I am going to ask counsel to please identify themselves for the record.
Good morning, Your Honor. Mark Durso for the State of Connecticut.
Good morning, Your Honor. Tatiana Messina for the State of Connecticut.
Good morning, Your Honor. Kevin Smith for the defendant, Raul Valle, who's at my side.
So, court would just like to note for the record that the court did prepare a draft jury charge, which was presented to counsel for review. Prior to closing arguments this morning, the court did have a brief informal conference with counsel regarding that particular jury charge, which will be marked as a court exhibit and put in the court file as a draft copy of the jury charge. I do usually go through each of the sections just to determine whether or not there are any questions or any changes or requests that have not been made to the charge in accordance with anything submitted by counsel. So I'm first going to start with the state and ask the state, did you have an opportunity to review the draft jury charge that was provided to counsel?
The state has had an opportunity to review the draft, Your Honor.
All right, and let me just ask the clerk which court exhibit this would be in terms of referencing for ID.
It would be exhibit number 3. Court, yes.
All right, so this is court exhibit 3 for ID. All right, and then I'll move over to the defense. Attorney Smith, have you had an opportunity or ample opportunity to review the proposed charge in this case?
Yes, Your Honor.
All right, and so I'm just going to go through sort of each of these sections to make sure that the court is not missing any argument that wishes to be made on behalf of the charge that the court intends to provide to the jury in this trial. So we're going to start with the court's duty to instruct and function the court and jury counsel. Any changes or requests that you're looking for regarding those sections?
No, Your Honor. Nothing from the state.
None from the defense, Your Honor.
All right, moving along to presumption of innocence, burden of proof and reasonable doubt. Any changes or problems with the charge that you'd like to raise at this point?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, thank you. Going forward, evidence direct and circumstantial evidence, are there any requested changes or comments that you wish to make on the record?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
Okay. Redacted exhibits, I know that counsel is of the opinion that there aren't any redacted full exhibits in this trial, so I will be changing that language to accommodate that concern. So it's basically going to read, if there are any exhibits that have been accepted into evidence as redacted versions of the original, please note these redactions were made by way of agreement and the charge will continue on. Is there any comment or concern regarding the court's change to that section?
Not from the defense, Your Honor.
Nothing from the state, Your Honor. No.
Okay. All right, moving forward to credibility, any questions or comments regarding that section of the proposed charge?
No, Your Honor. Nothing from the state.
Not from the defense, Your Honor.
Witness with a cooperation agreement? Any
Nothing.
concerns?
No concerns from the state, Your Honor.
Not from the defense, Your
All
Honor.
right, and just to confirm, those appear to be states exhibits 94 and 96 with respect to Jack Snyder and Tyler Gustavo respectively, is that correct?
Yes.
Yes, Your Honor.
Thank you so much. All right, testimony of police officials and expert testimony. Any questions or comments?
Nothing from the state.
Not from the defense, Your Honor.
All right, court has inserted Dr. James Gill, Dr. Ryan Joss, PA Eric Black, and Dr. Rizal Crombie. Those witnesses continue to stand and provide opinion relative to certain conditions, certain results, and certain definitions and approaches of certain standards. So is there anyone that should be included here or anyone that you feel should not be included here?
I don't believe so, Your Honor.
Not from the defense, Your Honor.
Thank you. Defendant's testimony and proximate cause, anything on those two subsections?
Nothing from the state, Your Honor.
Not from the defense.
All right, specific intent, I know we went through these, but I just want to make sure that we have this right and that the court is charging with respect to the intent required to be proven by the state relative to the charges. I want to go through it. So count one, murder and man in first degree intentional as a lesser included. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Count two, assault in the first degree intentional and assault in the second degree intentional as a lesser included. Correct?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Count three, assault in the first degree intentional and assault in the second degree intentional as lesser. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And lastly, count four, assault in the second degree intentional. Correct?
That's correct.
Yes, Your
No
Honor.
other charge contained in any of those counts that you believe requires a finding of specific intent?
No, Your Honor.
No, Your Honor.
Moving forward to recklessness, any changes or comments?
Nothing from the state, Your Honor.
Uh,
Other than with regards to the concept of recklessness, just so the jury is aware that it is a lesser included offense to count one and not, yeah.
Thank you. So we did discuss that in our informal briefing on this charge, and the court has made that change on the charge that you will get, and that will be going to the jury. So, and we'll have an opportunity to review that again. So I just would like to go through the concept of recklessness to make sure that we are all on the same page as to the specific mindset that has to be driven by the state relative to the charges. Count one, manslaughter in the first degree reckless as a lesser included.
Yes, Your Honor.
Yes, Your Honor.
Count two, assault in the first degree reckless as a lesser included. And
Yes, Your Honor.
assault in the second degree reckless as a lesser included.
Yes, Your
Yes, Your Honor.
Thank you. Count three, assault in the first degree reckless as a lesser, and also assault in the second degree reckless as a lesser.
Yes, Your Honor.
Yes, Your Honor.
And lastly, count four, assault in the second degree reckless as a lesser.
Yes, Your Honor.
Yes, Your Honor.
Evidence of intent and motive, anything under those sections you'd like to discuss?
Nothing from the state.
No, Your Honor.
Consciousness of guilt, has everyone had an opportunity to review the state's claims? Any concerns or questions or comments that anyone would like to make?
No, Your Honor.
No, Your Honor.
Identification of the defendant, any questions, concerns?
Nothing from the state.
Not from the defense.
Specific charges brought by the state, again, the court will be modifying the charge to include substitute information as opposed to just information. I will be providing additional bills and highlight, but substantively, is there anything regarding first the introduction to the specific charges that you'd like to discuss?
No, Your Honor.
Not from the defense.
All right, and again, as to each of the four counts, when we discuss elements, even on the lesser included, I will be directing the jury as to the number of elements that must be found as well.
Yes, Your Honor.
So that will be added. So count one, murder, anything substantively under that count that you'd like to discuss?
Nothing from the state.
Not the defense, Your Honor.
Lesser included offense to murder, we'll start with manslaughter in the first degree, intentional, anything that you'd like to discuss substantively there?
Nothing from the state.
Not from the defense, Your Honor.
Manslaughter in the first degree, reckless, anything substantively you'd like to discuss there?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, and it's my understanding that those are the only two lesser included offenses the state has requested, is that correct?
Correct.
And nothing from the defense, correct?
That's correct, Your Honor.
Very good, thank you. All right, please, let's move on to count two then, assault in the first degree. Anything regarding assault in the first degree intentional that you'd like to discuss?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, lesser included offenses to assault in the first degree intentional. We'll start with the introduction, anything there that you'd like to discuss?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
Thank you. All right, first lesser included assault in the first degree reckless, anything substantively there?
Nothing from the state.
No, Your Honor.
Second, B, assault in the second degree intentional, anything substantively there?
Nothing from the state, Your Honor.
No, Your Honor.
And moving on to C, then assault in the second degree reckless, anything substantively incorrect or inaccurate, you'd like to comment about that?
State sees none, Your Honor.
Not from the defense, Your Honor.
Okay. And again, I just want to add there, we did discuss informally, but I will be instructing the jury immediately thereafter that they're going to deliberate if and only if they have found the defendant not guilty on the other respective charges. So I just want to make clear that, again, relative to count two, the only lesser included offenses that have been requested on behalf of the state include assault in the first degree reckless, assault in the second degree intentional, and assault in the second degree reckless. Is that correct?
That's correct.
And nothing from the defense?
Not from the defense, Your Honor.
All right, moving on to count three. Assault in first degree intentional as to a different victim, Thomas Connolly Jr. Anything substantively under that count?
Nothing from the state, Your Honor.
Not from the defense, Your
And
Honor.
I will, of course, fix the spelling cross-meaning. All right, so I have the same lesser included charges on count 3 as I did on count 2. I've heard from you on count 2. Is there anything additional relative to count 3 that you'd like to discuss?
Nothing from the state, Your Honor.
Not from the defense.
All right, and the same question, same lesser included offenses. Were there any additional included offenses that the state was requesting?
No, Your Honor.
And nothing from the defense?
Nothing from the defense.
Moving on to count 4, assault in second degree intentional. Page 43. Is there anything substantive or any comments that you'd like to make regarding that particular count, the way that it's set up?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, and then we have lesser included offense to assault in second degree intentional. Only one lesser included that includes assault in second degree. Reckless. Anything on that?
Nothing from the state.
Not from the defense, Your Honor.
And just to be clear for the record, the state did not request any additional lesser included offense.
That's correct, Your Honor.
And nothing from the defense.
Nothing from the defense, Your Honor.
All right, moving on to self-defense, defense of others. There will be some initial direction to the jury concerning an independent and separate determination to be made as to each of those defenses as they're separate, although they're related. Aside from that, is there anything else under self-defense or defense of others that either of you would like to address with this board?
Nothing from the state.
Not from the defense, Your Honor.
All right, so I will note that I did receive, let me just, let's stick to this section. I did receive state's request to charge on combat by agreement. My understanding the state was kind of withdraw that.
I'm going to withdraw that request to charge, Your Honor.
All right, so noted on the record. Moving forward to sympathy, we will obviously add complainants to that list of people in the last sentence and persons. Any changes there?
Nothing from the state.
Not from the defense, Your Honor.
Okay, implicit bias duties upon retiring, anything there?
Nothing from the state.
No, Your Honor.
No taking, anything there?
Nothing from the state.
Not from the defense, Your Honor.
So where it says you may only deliberate when all 12 be present in the jury, from there down, I do intend to add an additional subsection in closing. Any comment with that?
No objection to that.
No, Your Honor.
Thank you. Is there anything that the court has been requested to charge that the court has not charged that you would like to discuss on the record?
Nothing from the state at this time, Your Honor.
Not from the defense, Your Honor.
All right, and is there anything that has been contained within the charge that either of you take objection to at this point and would request further argument?
No, Your Honor.
No, Your Honor.
So the court is wrapping up some graphical error corrections on the charge itself. Court is almost done with that. Before the court charges, you will of course have an opportunity to review that to make sure that it is in accordance with the changes that have been suggested and or told to you that would be made regarding this charge. Before we begin closing arguments, would you prefer to have a completely amended jury charge? That's up to you. I'm happy to do that and provide that to you before we start closing.
The state does not require that at this time, Your Honor.
Defense doesn't need that, Your Honor. Thank you.
And then my last question would be, would either of you like to take a few moments to either gather exhibits or make yourselves comfortable and well, or gather your outlines for your closing arguments before we proceed forward with those closing arguments?
The state's prepared to proceed, Your Honor.
Defense is prepared to proceed, Your Honor.
All right, is there anything else that the court needs to address prior to bringing our jury in for closing arguments?
No, Your Honor.
Not at this time, Your Honor.
All right, so that you both understand, you do have 1 hour. The state obviously has the opportunity to break its argument into 2 sections. The state will go first, followed by the defense, and then if the state does choose to break its argument into 2 sections, the state will have an opportunity to get up and address the jury with whatever time the state has left. Would the state be asking the court by way of the clerk to flag any timing?
Yeah, I would probably, I intend on using rebuttal time.
So how much time?
I anticipate my opening remarks to be around 20 or 25 minutes, maybe a little less, I don't know for sure, but
So you'd like to reserve at least 30 minutes?
yes, that would be fine.
All right, so we'll just give you a little tiny nudge after you start going over, because we all get caught up in closing arguments. So that seems to be sufficient. Was anyone seeking any additional time? I feel like they need additional
I don't think so, yes.
No, Your Honor.
Anything further?
No, Your Honor, not from the defense.
All right, very good. So at this point in time, we'll go on to the thank you. All right, welcome back, ladies and gentlemen, the jury from Thank you. So I would ask first to have counsel stipulate on the record the past.
The state will stipulate, Your Honor.
Defense will stipulate, Your Honor.
All right, so before we begin, you may be seated. Ladies and gentlemen, you're now about to hear closing arguments on behalf of the parties. The state will have the opening or first argument concerning closing argument. Then the defendant will have an opportunity to also make an argument to you, and then you will hear from the state again, perhaps. It's my understanding that you will hear from the state a second time in this particular case. Now, although the state has two arguments, both sides get the same amount of time to present their argument to you. That time is a total of 1 hour. The state gets 2 opportunities to present to you because the state does have the burden of proof in this particular trial. So we will hear from the state, we'll hear from the defense, and then most likely the state again. There may come a point in time where I have to interrupt defense counsel if timing is off a little bit. So please don't hold that against anyone. That's my call. So I hate to interrupt counsel, but I might have to. All right, we'll see how the closing arguments go, and then we'll decide what we're going to do relative to our next hearing. Thank you so much for your continued patience, as well as your attention to this particular trial. Lastly, I see a lot of you with your notebooks, and that's my bad. I should have had the clerk take them from you. I'm going to ask you not to take notes. I'm going to instruct you not to take notes during closing argument. And the reason that I do that is because closing arguments are not evidence. No matter what the attorneys say to you is not evidence. So you've heard the evidence that you're going to hear in this case. This is the opportunity for counsel to argue to you. So I won't have you take notes during this time. I would ask you just to pay attention to counsel, listen to their arguments, and then I'll have an opportunity to address you. Thank you so much. I would invite you to speak.
Thank you, Your Honor. Good morning, ladies and gentlemen. So I was actually just going to address that arguments are not evidence. This is argument, right? You've heard all the evidence that you need to hear. At some point in time, you're going to decide this case based on what you heard in court. But I wanted to take a moment to thank each and every one of you for giving us your time. It's been 2 weeks, over 2 weeks. All of you have listened diligently. You've given your time. You've given obviously your lives outside of this court are more important. But this is a very important civic duty, and it does not go unrecognized. So we thank you very much. As the court indicated, this is my first of 2 opportunities to talk to you about this case. And in this case, there have been many witnesses who've testified. This happened 3 years ago. They provided different perspectives on what they saw, what they heard, what they did. And the majority of the witnesses were teenagers when this happened. It was a horrific event. But the main story is the same. The main story is the same. The horrific event that was etched in their minds was the same. This case is not about who did it, what happened, how it happened, when it happened, what happened. This case is about Raul Valle, the defendant, who brought a knife to 43 Laurel Glen on May 14th of 2022 and provoked a fight and stabbed 4 kids 9 times, killing 1. That's what this case is about. So what happened on May 14th of 2022? You heard testimony about this party at Lazy Brook, where it was a St. Joe's party. Kids were hanging out, they were drinking. typical high school party. Probably not the first time there's been alcohol at a high school party, right? Not that anybody's condoning it, but it happens. So there's this party, the defendant's there with his friends, he's wearing this helmet, and in come in some Shelton High School kids, Ryan Hines and Griffin Marcinzik. And because this is a St. Joe's party, not a Shelton party, they can't come in. So the defendant and Mr. Snyder and De Silva take it upon themselves to kick them out. They steal the beer from Ryan Hines. At some point in time, it gets heated. They're arguing back and forth. And at some point, it ends out into the driveway. And when it's out into the driveway, there's this agreement. I'll fight you for my beer. So Jack and Ryan square up. And just as they're squaring up, who starts the fight? The defendant starts the fight. He sucker punches him in the back of the head. And then after he sucker punches him in the back of the head and the fight goes to the ground, he takes his helmet and uses it as a weapon and slams it into Ryan's head. You heard the defendant testify. He would have you believe that that was a push, that he pushed Ryan Hines and that he didn't hit him with the helmet. I would submit to you that if you watch that fight, you could judge for yourselves what you see in the fight. And by the way, while I'm talking about witnesses, the judge is going to give you a credibility instruction, right? You're all going to have to assess the credibility of each and every witness who testified. And if you recall during voir dire, I think I asked each and every one of you the same question. You think it's possible that somebody could get on the stand, raise their right hand, and tell the truth? And you all said yes. I also asked all of you, do you think it's entirely possible that somebody could swear to tell the truth, believe they're telling the truth, and simply be mistaken about something? And you all said, yeah, that's possible. But I also asked you, do you think it's possible if somebody could get on that stand, swear to tell the truth, and look all of you in the eye and outright lie to you? So again, when you're assessing the credibility of each and every one of the witnesses who testified, that's what you have to go through. And you have to go through what they said and how does it line up with the rest of the case, right? The defendant who took the stand is also subject to that same credibility instruction. He put his credibility in issue as soon as he took that oath. The video I would submit to you tells a very different story than what the defendant testified to a couple days ago. So after this fight, they get in Jack's car and they leave Lazy Brook and they go to Trumbull High School. And at some point in time, as they go to Trumbull High School, there's this basketball group chat. You heard testimony that Shelton kids were in it. You heard testimony that Ryan Hines was in it. You heard testimony that the defendant was in it. You heard the testimony that De Silva and Snyder were in it. And you also heard testimony that they wanted to fight the Shelton kids at Trumbull High School. They were there for about 20 minutes. This wasn't over. Of course, there was argument and heated emotions about what had just happened at Lazy Brook, but now they want to meet up at Trumbull High School. So what does the defendant say? The defendant tells them to slide on over to Trumbull High School multiple times in the group chat. Slide right over, because they want to fight. Shelton kids don't want to go to Trumbull High School. Somebody puts an address, 43 Laurel Glen, in the group chat. Come to Laurel Glen. So they go over to Laurel Glen. The defendant would have you believe that he had no idea that they were going to fight, that they were just going to another party. I would submit to you that you need to assess whether or not that's credible during your deliberations. But in any event, you heard testimony from several witnesses that the defendant wanted to go to Lazy Brook or Laurel Glen to fight. He wanted to fight at Trumbull High School and he wanted to fight over at Laurel Glen. And that's why they were going. And as a matter of fact, when they got to Laurel Glen, the defendant lets all the kids know that they're there. There's a few kids outside, more kids come outside, and at some point in time, Tyler Rich and his friends are outside. They're around the car in front of his house at 43 Laurel Glen, and there's some testimony that at first it was peaceful, some testimony that it got heated, arguing back and forth. Things were being thrown. You heard testimony from Aiden King. I saw Raul sitting behind Jack Snyder, who was driving. Tyler DeSilva was in the front seat. The defendant even said Aiden King's his boy. And Aiden King got up here and said, at some point in time, the defendant said, "Get your friends away from my car. I'm going to break a bottle over somebody's head." Again, all of these things going to what was his intent that night. So things are thrown at the car. The car was being shook by the Shelton kids. There's some testimony that things were being thrown back. Car takes off, drives up and down the street. Things are thrown from the car, things being thrown at the car. At some point in time, they end up at the end of the street, close to the intersection of Farmhouse Road near 36 Laurel Glen. Now, this is 11:40 at night. You heard testimony. This is Jack Snyder's car. The defendant's already out of the car. Tyler DeSilva gets out of the car. I would submit to you that the defendant being mad, angry about what had just happened to Jack Snyder's car happens just prior to this video starting. And that's the point when he asks him for the knife. He asked him for the knife. He said, "Jack, give me the knife. Where's that knife? Give me the knife." He gets out of the car. Tyler DeSilva gets out of the car. Keenan, Dimitri, Will, Mackenzie walking away. Everybody with an earshot of that conversation. You heard people testify about what they heard about the knife. How you heard Keenan Frasick. He was going insane. He was pissed off about what had just happened to the car. You heard Dimitri. He was angry about what had happened to the car. Tyler DeSilva, Jack Snyder. You heard Mackenzie say, "I heard somebody asking about a knife, but I don't know exactly who it was," because she's walking away, right? So we know the knife comes out at that point in time. He's angry. He arms himself with a knife at that point. But then the Shelton kids come down the street after having just told them, "Get out of here, get the heck out of here." Now look, was it right that things were thrown at the car? 100% no. It was not right at all. Wasn't right that people were hitting the car, shaking the car, and people throwing things from the car at the kids or at the cars parked on the side of the street. That wasn't right either. But at that point in time, nobody called the police. They drove down the street. Could have called the police at that point. Could have said, "Hey, someone just damaged my car. I want them arrested for criminal mischief." They didn't do that. The defendant at that point in time thought it was very important to arm himself with a 3-inch bladed knife at that point. So the kids come down the street. You heard Tyler Rich, Charlie Connery, Ty Wood, Ricky Fiola, a few other kids go down the street. And yeah, there's things thrown at the car. They throw things back, right? But there's no physical altercation between the parties down the street. Because if there was going to be a physical altercation initiated by the Shelton kids, it would have happened right then and there, but it didn't. Right? Again, Tyler Rich running down the street. Get out of here. You guys got to get out of here. Now, you heard some testimony that somebody threw this can of WD-40 or PB Blaster back at Tyler Rich, and he's walking away. And at some point in time, he sees the defendant, and the defendant's walking towards him. So he sprays him to get him away. Ricky Fiola sees this. He's within a short distance to see this happening. At some point in time, Ricky Fiola approaches the defendant and has a conversation. And what did you hear him testify to? He said, "Listen, hey man, it's really messed up what he did. He shouldn't have sprayed you with that stuff. But look, there's a lot of us, and there's only like 5 of you. You guys should probably just get out of here." And while he's having that conversation, what does Ricky Fiola see? Ricky Fiola sees the defendant holding a knife in his hand. Ricky Fiola turns around, walks back. The rest of the Shelton kids walk back to Tyler Rich's house. Again, no physical altercation down the road. Mackenzie Traficante is calling her sister, "I need a ride home." At some point in time, Will, Dimitri, and Keenan get out of the car. And they don't want to be a part of anything. They want to ride home. They stay down the end of the street. Rides are being called. Will calls his girlfriend, "Come pick me up." I think you heard testimony from Mackenzie Traficante, who said, "Lito, just stay down here. Stay with me. Come home with me." That's not what he wanted to do. Because Ryan Hines, who he had just sucker punched in the head earlier that night and helmeted back at Lazy Brook, who was now at this party. Now he wanted to go back and face those kids, but he wasn't going back just him. He was going back with a knife. Because who else goes back to a house, right? I mean, you heard testimony when he was in the car with a bunch of other people, and the car was being shook and rocked and thrown at, that he was panicked, he was frightened, he was scared, he was terrified. If you're all those things, why are we not staying down the road? Why are we not waiting for Mackenzie's sisters to come pick us up? Why are we not calling somebody to come pick us up? Because he wasn't scared, terrified, panicked. It's just simply not, that's not the case. He was mad, he was pissed, he was angry, and he had a knife. So they wanted to go back and go and confront those kids. Now there's some testimony that Tyler wanted to go talk about the damage, and he knows Tyler Rich, maybe he could work something out. But the bottom line is, he's the one that was going ballistic about the car. Yeah, sure, Tyler and Snyder were angry, but he's going crazy, and he's the one that arms himself with the knife. So he gets back in that car, he makes the willful decision, right, to get back in that car, armed with a knife, and go back to the very house he was told to leave. But he would have you believe he was panicked, scared, frightened, all of those things. So Jack pulls up to the 43 Laurel Glen. The defendant and Mr. De Silva get out. You've heard testimony from several witnesses that Tyler's on the left, the defendant's on the right. They move on to property. They were told to leave, so now they're trespassing. Some kids were outside. Got a little bigger when people heard, oh, people are here. You heard Tyler Rich say, I told him to get the F out of my property. The defendant walks up. Ryan Hines, Faison Teal, Tommy Connery somewhere behind them, but closer in proximity to the defendant. Ty Wood there is also there. And you heard Tyler Rich say, I was yelling at these kids, get the hell off my property. I looked out of the corner of my eye and I saw Raul cock his arm like he was going to punch Ty Wood. And that's when I just hauled off and cracked him in the face. And it was on. So I would submit to you, if the defendant walked on the property, confronted those kids, and started to throw a punch or pretend like he was going to throw a punch, he was the initial aggressor in the altercation by coming back, by approaching those kids, and by cocking his arm. He was the initial aggressor. He provoked the fight and started the fight. He gets hit, it's on. All right, now I can claim self-defense. Now I can take this knife out that I have in my pocket while I'm on the ground, open it up, right? All intentional conduct, and start stabbing kids, right? You heard him testify, I was flailing my arms. I would submit to you, if you look at any of the injuries on these kids from 3 years ago, those are deliberate stab wounds. Those are not flailing slash marks. Stab wounds. So he stabs Ryan Hines 3 times. He stabs Faison Teal in the arm. Again, upper, right? Left arm here. Hines up in the chest as he's working his way down. And Tommy Connery, you heard testimony from Tommy Connery, who comes over and he's trying to push him away. And he's on the ground. The defendant's on the ground, and he comes right after him and starts stabbing him in the leg 4 times. Deliberate. Again, what was his intent? This wasn't self-defense. He went into that fight already armed. His response to this fight was unreasonable when you look at it in totality. It was a fist fight that escalated by his doing because he was the only one there with a weapon. At some point in time, the defendant goes back to the car that's waiting for him. He would have you believe he was chased. I would suggest to you that the video shows a different story. But nevertheless, he's back at the car, looks back, and wants to run back in. He purposefully runs back in with the knife. And you hear Charlie Connery yelling, "He's got a knife, he's got a knife, he's got a knife." And there's another person there yelling, "Get out of here, bro." Because again, the Shelton kids didn't want them there. There was a communication to leave. Again, all of these things could have been prevented. This is Jimmy McGrath just before he gets stabbed, at the end of the fight. He's not engaging the defendant, but he would have you believe that he or somebody else was, so that he can cloak himself with self-defense or defense of third parties. He had a duty to retreat and not even go after Jimmy McGrath. He was unarmed and he did nothing wrong. And even if you believe from the evidence that Jimmy was involved somewhere in the fight, somewhere, which there's been no evidence of that, but even if that's what you can infer from the video, I would submit to you that self-defense is not retaliatory. It's defensive. You can't come back and stab somebody just because you're mad. And that's exactly what happened here. He came back from the car. He ran back at people who were already, the fight was already done. Tyler DeSilva clearly in the road. The fight was over. Kids were screaming back and forth. Tyler DeSilva even said the fight was over at that point. You hear, "Get out of here, bro." And at the very end of the video, you see Jimmy McGrath step back like this to try to avoid the fight, the stab wound, the deliberate stab wound in his chest. He didn't stab him in the foot. He didn't stab him in the lower leg. He stabbed him right in the chest. What was his intent when he did that? When that happens, you hear Jimmy McGrath yell, "I've been stabbed," and he collapses. He collapses.
Yes, sir! Come on! Let's go, nigga!
So he unnecessarily stabs Jimmy, right? You're going to hear an instruction about intent, right? And I'm sure the defense attorney's going to get up here and argue, he didn't wake up that morning, want to kill anybody or stab anybody. It's not what intent's about. Intent can be formed in an instant. It can be formed within a moment. I would submit to you at the beginning of that fight that was not on video, as soon as he got hit, he informed the intent, the specific intent to stab people and cause serious physical injury, right? He went back to the car and he informed the same intent when he turned around and saw Jimmy. "I'm going to stab this kid and get out of here." Why else would you stab him in the heart? You stab him right in the chest, piercing his heart. After he gets back to the car, he tells you that, or Snyder indicates, gets back in the car and he says, "I just stabbed like 4 kids." So he knew how many kids he stabbed. He knew how many kids he stabbed. But he knew he stabbed kids. He got on the stand here. I don't know if I stabbed anybody. Right? We heard that testimony. I don't know if I stabbed. I was the only one with the knife, but he couldn't even say it. But he said it that night. He knew he stabbed kids that night. So we know he did it. They go back down the road. No, before we get there, they take off. DeSilva jumps in the car. They take off. They take a left. They go down Adams Drive. They're at the cul-de-sac. He says, "Stop the car," and throws the knife into the woods. Why? Consciousness of guilt. You'll hear an instruction about consciousness of guilt. Why are we getting rid of the weapon, right? Gets back in the car, go, go, go. They go back down to 36 Laurel Glen. Mackenzie's sister's there. He tells Jack and Tyler, "I'm going home with Mackenzie." Jumps in the car with Mackenzie, and the cars leave the area. Mackenzie drops off Keenan and Dimitri, and then they subsequently drop off the defendant at his house. Mackenzie was mad, right? She told you, "I was pissed. I didn't want to be there. I was mad at him. They were going there to fight. I didn't want to be there. I didn't want to be involved in any of that." They were all going there to fight that night. But after the defendant gets dropped off, you hear about the text messages that go back and forth between Mackenzie, who was his then girlfriend, and Raul. And he's saying things like, "I can't text anything. I wasn't there. You know I wasn't there. Nothing is happening. Don't text me. I'm going to Florida. I didn't do anything." That was text messaging. They didn't want to put anything in writing. You also hear that he spoke to Tyler DeSilva on the phone. And when he spoke to Tyler DeSilva on the phone, he says, "Dude, I fucked up. I'm sorry. I don't know what to do." Because he knew what he was doing that night, and now he's having buyer's remorse. So again, what was his intent, right? You guys are really going to be able to examine what his intent was. And the judge is going to give you an instruction such as, there's no particular length of time necessary for the defendant to have formed the intent. Intent can be formed in an instant. It can be created in a moment. Intent may be, and usually is, inferred from the circumstances of the crime, since no witness can come into court and testify that they looked into a defendant's mind and saw what his intention was. You can look at the number of wounds inflicted, the location of those wounds on each person's body, the type of instrument used to cause those wounds, and his conduct during all of this. I would submit you could even look at the conduct from Lazy Brook. What was his conduct during that fight, and then for what his intent was later on that night. In this case, the state contends that there were 9 stab wounds inflicted by this defendant on 4 different individuals. They were stab wounds, not slashes. I would suggest to you that a person who stabs multiple people multiple times in areas of the body that would cause serious physical injury and death intended to cause those serious physical injuries and death. There's no other rational conclusion. So that's what this case is about. The defendant was enraged about what had happened earlier. He armed himself and he returned to a house to face those kids with the intent to stab somebody. He could have waited down the street. They could have called the cops. He didn't have to go back. He did. He intentionally went back. It doesn't make sense when someone says, I was very scared, frightened, and panicked, to go put yourself back in that situation. It makes 0 sense. And because of his conduct, 3 people are going to have to live with scars for the rest of their lives, both mentally and physically. And James McGrath lost his life unnecessarily. And the ripple effects that that's caused his family. The credible evidence in this case shows that on that day, he intentionally caused physical injury to Faison Teal. He caused that injury by stabbing him in the upper arm with a dangerous instrument. With regards to Tommy Connery, the credible evidence shows that he intentionally caused serious physical injury to Tommy Connery. He specifically intended to cause that injury by stabbing him 4 times in the upper leg, causing deep stab wounds. You heard testimony from his doctor. She was concerned about compartment syndrome and him losing his leg. Deep stab wounds. I mean, deep stab wounds. These are not flailing slash marks. These are deep stab wounds. Again, the manner in which the wounds are the wounds are inflicted. It's not corroborative of slash marks. And he did that with a dangerous instrument. With regards to Ryan Hines, he intentionally caused serious physical injury to Ryan Hines. He had the specific intent to cause that injury by stabbing him 3 times in the upper torso, causing a collapsed lung and other injuries to his lower abdomen and hip area. And he did that again with the dangerous instrument. And with regards to Jimmy McGrath, he formed the specific intent to kill Jimmy McGrath at the moment he came back from that car, turned to him, and plunged the knife into his heart. He didn't slash at Jimmy McGrath. He plunged the knife into his heart, through his rib cage, and through his heart, and the poor kid bled to death right there on the front lawn. The judge is going to give you an instruction on sympathy. You need to follow that instruction. And I apologize for getting a little choked up here, because I have a son as well. And I can't imagine what it feels like to have that happen. And I hope no one else ever has to. I hope no one else has to go through this ever. It's terrible. I apologize for taking a moment. But again, the judge is going to give you an instruction on sympathy, so please follow that instruction on sympathy. But we are confident that after you review all of this evidence, you will find the state has proved each and every element of the charge beyond reasonable doubt. You'll find that the defendant intentionally caused the death of Jimmy McGrath, intentionally caused assault in the first degree to both Ryan Hines and Tommy Connery, and intentionally caused physical injury to Faison Tail with a dangerous instrument. We're confident after you review all the evidence, you'll determine this was not self-defense. He provoked this fight, he was the initial aggressor, and he had a duty to retreat, and he should have. The state urges you at this time, well, after you deliberate the evidence, we urge you that you find the defendant guilty of all the crimes charged in the information. The defense will now have an opportunity to speak with you, and when he's finished, I'll come back and speak with you again. Thank you.
Good morning, everyone. Y'all are probably tired of seeing me come up here and set up with all my stuff, so I'll just get right into it. This might be a hard case because it involves young people. It might be difficult because it involves young people, right? But it is not a complicated case. It is a case about the most basic right that any of us have, which is the right to defend ourselves when we're faced with people that are intent on doing us serious physical harm. That could be as much as death, serious disfigurement, and all the other things you're going to hear about in that instruction. You've heard from the state here telling you, I guess, that Lido Valley is a criminal mastermind who came over there with the plan to be able to use all of this so that now I can claim self-defense. You heard Mr. Valle get on the stand. Mr. Valle, a criminal mastermind, can put together a plan like that? And back home, you know, we'd say, son, bless your heart, but that was mighty stupid. There was a whole lot of stupid to go around that night. There was a fire that got lit earlier in the night, and it started with all that drinking that was going on. And nobody there to say, what are we doing? How do we come into all of this? That's the first fire that was lit. And there were a lot more along the way. But again, not a complicated case. Mr. Valle took the stand, he talked to you, he didn't have to do that. Mr. Valle used a 3-inch pocket knife that Jack Snyder gave him, that Jack Snyder brought, that Mr. Valle didn't even know existed prior to that night. Mr. Valle didn't even know existed prior to Mr. Snyder giving it to him. Where was Lido Valley seated when Jack Snyder pulled that knife out and had it on his lap? Was he in the front passenger seat? No. De Silva. Lido Valley is behind him with Mackenzie Trafficante on his lap. There's no way he can see that knife in Jack Snyder's lap. And Jack Snyder's the one who told you he took that out and put it in his own lap because he was so scared about what was going on. So Lido Valley can't see that knife, doesn't know it exists. Mr. Snyder told you, There was no way that Mr. Valle could have known it was there before. He'd never brought it out. He'd never said to him, hey, I got this knife. Let's go riding over to 43 LGD and get a little payback. None of that happened. So it doesn't make any sense when Jack Snyder tells you that Lido Valle asked him for a knife that he didn't even know existed. Now I get it. Maybe some of you want to believe Jack Snyder and Tyler DeSilva. Maybe you say to yourself, gosh, those kids, nice looking kids, they get up here on the stand. Why shouldn't I believe them? Well, ask yourself, why should you believe them over Mr. Valle? Is there something about Mr. Valle and the way he came up here and took the stand and testified that tells you you should disbelieve him but believe those two? I didn't hear the state talk at all about Exhibits 94 and 96 when they were up here. Did you? What are Exhibits 94 and 96? I bet you remember. I hope it weighed heavily on your mind. Imagine if I came up here and asked you to believe witnesses. I can't even call them paid witnesses. They have something more valuable than any money they could ever be given. What is more valuable than a complete immunity agreement? Anything? Is there anything that a 18, 19, 20-year-old kid would not come up here and do or say in order to avoid any penalty whatsoever for their actions? Does that bother you? Does that disturb you? It should. Does that sound like justice for all? Does that sound like justice for some? Does that sound like equal justice to you? Gonna give those two kids immunity agreements. Jack Snyder drove the car over there, gives the knife over to my client. Tyler DeSilva gets in that same car, rides over there to 43 Laurel Glen Drive, says he's gonna go make peace. Listen, there was a lot of stupid going around that night. Tyler DeSilva got up here on the stand and told you, well, I thought I could go up and talk to them because I didn't have a problem with them. Maybe he did. Maybe some of you sitting here look at these kids and think of your own kids. State's attorney did, I know I did. Would any of you put your faith in something as important as this in a 16 or 17-year-old? Would you have reason to doubt that maybe they would fail to go to the grocery store and get everything that you had for them on a list? But we're gonna sit here and expect these folks to give us the evidence that we need in order to convict somebody of murder who's charged with the same things that these folks could and should be charged with. They told you that. They know what they're exposed to. I went over it with them. I asked them about it. They know exactly what they're doing when they're coming in here. Jack Snyder's story doesn't make any sense. He gave him the knife because he asked for the knife that he didn't know existed? It's not just implausible. It's not just improbable. It is impossible. You don't ask for something that you don't know exists. He didn't know it existed before that moment. So we watched the ring video. The ring video is the 36 Laurel Glen Drive. That's Exhibit 44. You'll have that available to you. You see the car stop. You see Mackenzie get out. She's walking up ahead. Raul's already on the curb, a little ashamed, in a bad situation here. Mackenzie's obviously upset with him. She's walking down towards the curb. Tyler DeSilva gets out of the front. And then the car stops. And it's there for some time before it drives off. And Mr. Valle told you that's when Jack Snyder threw him the knife and said, just in case. Just in case what? Just in case this situation that I caused over here at 43 Laurel Glen Drive comes running down the street at you, throwing things and hollering things, and I'm about to drive off and leave you? Does that make more sense than, he was pissed off. He was the most pissed off. He was angrier than anybody else there. And he asked me for that knife that he didn't know existed. Jack Snyder has every incentive in the world to make these folks and you promises that he just can't deliver on. He's got there is no more powerful incentive in the whole world than what he's got. What are the terms of that agreement that he was given? He's got to come in here and testify truthfully. But who makes that determination? Who's he working for when he's under that immunity agreement? Not me. Not you. The state. And what did they all tell you, almost without fail, about what they did before they came in here? They met with the state's attorney a number of times. To do what? To get ready, to make sure that when they took that stand, they were going to testify truthfully. And I put air quotes around that, because what does truthfully mean in this instance? To those guys, as they told you, it meant not deviating from the things that they had said. The things that they waited 7 months, and after they'd gotten an immunity agreement, before they were going to say anything. Now, when we were in here during jury selection, some of you said, well, there can be a lot of gray. There's more than two sides to every story. That was a bit of truth. How many sides to a story did we get here? And some of you said, well, a lot of people will lie. And you said that maybe you had a little bit of an idea about what had happened here. You've got way more of an idea now about what happened here. And some of you said, well, I don't expect everyone to testify truthfully. People may want to defend or protect their families. You need more than just common sense to determine credibility. Some of you said you had an experience with a kangaroo court. And you know what that's like. Don't turn this into a kangaroo court by putting any more weight into the testimony of Tyler De Silva and Jack Snyder than what it deserves. And it doesn't deserve any more weight than the paper and the ink on which it is written, because that incentive is overwhelming. That's more than just defending your friends or your family. That's defending yourself. And some of you said, if we don't follow the law, our system wouldn't work. It's not here just for one person. It's not here just for a few people. It's here for all of us. And that's right. You all take seats that were laid out for you hundreds of years ago. You come in and you take those seats. And you got to put your sympathy aside. Sympathy for the victim, sympathy for the complainant, sympathy for anybody. It's got no place here. Some of you have experience taking things through a process, doing quality control and making sure that everything has been met along the way. Use that experience here. Does this make sense? Would this pass through quality control? I told you before, some of these witnesses, if not all of them, are promising more than they can deliver. Imagine if somebody tells you something that you know just can't be true. Somebody tells you they got to make a delivery and it's going to take them an hour and a half to get from here, in the middle of the day, through the city, down to DC in 3.5 hours. They're making you a promise because they want you to believe them. They know you'd be really happy if they could actually make that trip, but they can't deliver on that. That's more than what they could possibly do. That's what these witnesses are doing for you. They're telling you things that they can see that couldn't have been seen. Why are they doing that? They want to avoid consequences that Mr. Valle is now saddled with. They want to protect themselves. They want to protect their friends. And they want to protect the memory of a loved one that they lost. Now, during jury selection, I asked you all if you could be open to the idea of self-defense. And to a person, you told me that you could. Some of you said you'd had to use some self-defense before. And you said you'd be open to it and you could understand that the law allows you to use self-defense. To defend yourself, to defend loved ones. Whether or not you had experience with doing that, you said you'd be open to it. I don't know what you thought you were going to hear or what you thought self-defense looked like. Some of you had experience with it, some of you don't. But this is what self-defense looks like. It's messy. It's chaotic. It transpires quickly, and you don't have to make the best decision. That's not what the law requires. That's not. It's a higher bar than anybody could be expected to make. It requires that you make a reasonable decision, that you make a decision that you had a reason for. You watch those videos, you know there's a reason for the defense that he used. He's down on the ground. He's getting kicked, stomped, punched, and he's being given no reason to believe that that's going to stop unless he makes it stop. Nobody's saying, that's enough, guys. Everybody up. Just a few licks and then we'll let him go. That didn't happen. What did happen? People joined in the fray. There were at least 15 to 20 people out there, at a minimum. And you know that because if you watch that video, you can count them. Michael Sampieri, Sal Perry, Jacob Villalobos, Matthew Lockovich, Ryan Hines, Ty Wood, Tanner Chernowski, Tommy Connery, Charlie Connery. The list goes on. We heard about all of them. We see some of them. Alex Burnson. Some of them couldn't be identified. Those are at least the people that we can see. And Mr. Valle's down on the ground, getting kicked, punched, can't tell what's going on around him. Ryan Hines is on top of it. And Ryan Hines is punching him in the face. And Ryan Hines tells you, I didn't think he was aiming for me necessarily. Because he wasn't. He reaches in his pocket and he takes out the only thing that he's got there. The only thing at that point that he thinks is gonna make them stop because they've not given him any reason to believe that they're gonna do so on their own. And maybe you're thinking to yourself, well yeah, but he said he brought a knife to a fist fight. No, he didn't bring that knife to that fist fight. He had that knife in his pocket because Jack Snyder took it out and threw it to him. And he's got some kids running down the way. He drops, picks it up, sticks it in his pocket. Now you heard the state argue to you, well, you know, they submit that that's when he gave it to him now, is when we see it on that Ring video. Agreeing, I guess, with what Mr. Valle tells us, which is in fact, as you will recall, entirely different than what Mr. Snyder says, than what Keenan Frasick says. Snyder tells you he doesn't give him the knife until it's asked for, which again is completely ridiculous and unbelievable. But he tells you that happens after they're looking at the car. After he's dropped them off, driven down the street, leaving them there, comes back, and then everybody else who was still in the car gets out. Do you remember that? That was Jack Snyder's testimony. He didn't tell you that he threw it to him while they were right there. And Keenan Frasick, what does he describe? A mad scramble through the console, through the glove compartment. Where's that knife? Give me the fucking knife. Didn't happen. It's just unbelievable. It's not what Jack Snyder or anybody else describes. But Jack Snyder and Tyler DeSilva and all these other kids that are in that car, all these kids that had once been his friends, all these kids who haven't talked to him ever since that night, though they still remain very close with one another. Those kids all told you that Mr. Valle was the most upset of anyone there. More upset than Jack Snyder about his car. More upset than Tyler DeSilva, who was worried about the damages and how much it was going to cost. He was the most upset of anybody there. And he went into a rage. He was so angry. Gosh, never seen anybody that angry in my life. He goes digging through the car and this and that and the other. Why? Does that make any sense? Of course not. Not unless you start to think about what's motivating them to ostracize and distance themselves from Mr. Valle, to aggrandize what he was doing so that they can demonize him, so that they can wipe their hands at Mr. Valle. Oh, I had no idea. I don't know. He was so mad. He was so angry. I just thought we were just going to go get back in the car, and I was going to go make peace. It doesn't make any sense. Mr. Valle told you he and Tyler DeSilva were best friends. Again, it might have been mighty stupid to get back in that car. But there was so much stupid running around that night. And now Mr. Valle's the only one sitting here facing anything for it. Because he got in that car and had a pocket knife in his pocket. You'll recall not a single witness telling you that he got out of that car and came onto that lawn with that knife displayed. None of them saw it. He didn't get out dancing around with it, licking the blade, asking who wants a piece of this. None of that. He's not a person who carries a knife. It wasn't his knife. And mind you, one of the charges that you don't hear here is criminal trespassing. It was stupid to go on that lawn. I would agree with you. We could argue about that, and I would concede that. But it wasn't criminal under those circumstances. Those kids, for whatever their reasons were, had invited them there and wanted them on that lawn. What do they tell you? Did we hear a series of witnesses come in here and tell us all the things that they could remember so clearly, and they all could remember? I looked in the car. I might have been a long way away, but I could see Mr. Valle, and I could see Tyler DeSilva, and I could see Mackenzie Traficante. and I could see Jack Snyder. But then when it came time to tell us, well, who else was there with you? Who else went out into the front yard with you? I can't really recall. Really? But you told us that all those folks were your friends, lifelong friends. Grew up with them from childhood, been over to their homes. So comfortable that when they got to the house, they could walk right up and go in through the Bilko doors. That they could go downstairs, nobody would even blink an eye, right? And when they got down there, they could see their friends, they knew who was there. But then when they all went outside, do you remember this? It was everyone got up. All of us went together. Oh, really? Who were you beside? Ooh, I can't recall that, actually, now that you mention it. Oh, okay. Well, who was at the car? Some of them told you, there was a couple of us at the car, right? Maybe 3 or 4 of us at the car. Then others told you, no, there was maybe 10 of us that went to the car. And there were others that told you, no, there was more like 15 or 20 of us, and we were all around the car. Some of them told you, I didn't see anybody touch the car. I didn't see anything going on over there. It was peaceful, what I saw. And yet others told you, no, we had our hands on the car. We were rocking it. There was somebody bouncing up and down on the rear bumper. Who? I can't recall. Oh, okay, but you just went through a whole list of folks that you could tell us were there, that you saw downstairs, and you all went out together. So surely you must have seen Tyler Rich by the car. I don't recall. Oh, okay. What about Ty Wood? Where was he? I don't recall. You will have the opportunity to see all the evidence here as long as you want, as many times as you wish. Do a test. Do an experiment. Go through those witnesses. See when they can't remember things and ask yourselves if that's convenient, if it seems like they're protecting their friends. Or ask yourselves, is there something wrong with their memories? Why is it so selective? Why can they remember some things but not others? And do those things seem designed to protect their friends and themselves? Right? Tyler Rich has got to tell you that he told Tyler Da Silva to get the fuck out of here when he sees him on his lawn. Because what he can't come in here and tell you is he didn't tell him get the fuck out of here. He wanted him on that lawn. And he wanted for his friends and him to be able to jump them and get some payback. Because if he tells you that, and if he tells the cops that, then he and his friends could get charged. Maybe they get an immunity agreement. Who knows? But they certainly have to admit to some conduct that is criminal. And they're not gonna do that. They didn't do it that night. To the extent that they came in here and told you things that were different from what they told the cops before. I tried to point that out. I asked every single one of you during jury selection, probably looking at me like, what in the world is this all about? I gave you the parking lot example. Everybody remember the parking lot example? Right? I said, what would you be interested in knowing? Right? If you came out and you saw 2 strangers that you'd never met before, and they're each pointing at each other and saying, he did it, and you look at your white car, remember the white car? It's got a long red gash, remember the red gash? I said, would you be interested in knowing whether either of them drove a red car? You guys looked at me, you're kind of like, I guess. And I said, okay. Would you be interested in knowing whether or not there was any objective, other evidence that you could look at, like surveillance camera footage? He said, yes, that would be interesting to me. And I said, okay. Would you be interested in whether or not there were any eyewitnesses or people who claimed to be eyewitnesses? And you all said, yes, I think I would be interested in that. And I said, would you be further interested in knowing where those people were standing and whether or not it was possible for them to have seen what they claimed to have seen? And you all said, yes. And then I finalized that and I said, and would you be interested in seeing how all of that evidence either aligns or doesn't? And you all said yes. I know you did. because I wouldn't have chosen you otherwise. That's your job, is to look at that evidence. It's my job, based on what you told me, to try and show you those things about the evidence that gives you some doubt about what you're being told. You're being asked to align yourself with Tyler Da Silva and Jack Snyder. You're being asked to condone that testimony and accept that and say, I don't have a reasonable doubt about what those two fellas told me. Again, would you trust those two fellas knowing that that had that kind of incentive under any other circumstances where you had a decision as serious as this to make? If they were the two guys, the paid spokespeople, that were telling you about a surgery that you should get, would you want to know what sort of value they were being given to tell you that that was what you needed to do? Of course you would. Would you make a serious decision and not have a reasonable doubt about it on the basis of those two folks? Would you trust that kind of evidence under those circumstances? Of course you wouldn't. Don't start doing it now. Why would you? You'll never forgive yourself if you do that. Don't overlook your reasonable doubts. This system is built on reasonable doubt. It's fundamental because none of us were there. We're looking at it after the fact, and we're trying to determine, has the state proven its case beyond reasonable doubt? You may feel inclined to try and solve the crime or somehow make things right. That's not your job. You can't fix all the ills that led up to that night. Your job is to determine whether or not you have a reasonable doubt about what happened that evening based on the evidence that you've been presented. And I think you've got more than a single reasonable doubt. You've got reasons to doubt Jack Snyder. You've got reasons to doubt Tyler Da Silva. And you should heed those doubts. That's what the law tells you to do. Listen to your doubt. Give your doubt credence. It is, in fact, what binds us, because it's there for all of us. And if you don't follow that doubt and give it the credence that it deserves, you're not following the law. And you're leaving these seats in a lower place than they were there when you took them. Just as fundamental to our system is the presumption of innocence. And again, I know I asked every single one of you whether or not you could uphold that. Whether or not you could tell me as you sat there and looked at Mr. Valle that you could presume him to be innocent, despite the fact that he had been charged with these things. And again, you know, we made it kind of easy for you. This is not a case of a whodunit. This is not a case where we're claiming somebody else, who knows. No, this is not a case about who did what. With the exception, perhaps, I guess, of Faison Teal, as I think about it. I mean, there's no evidence really to show you that what happened to Faison, cut on his arm there, was as a result of a stab any more than Faison coming in and getting in a couple stomps, somebody pushing him from behind, and him getting a cut there. There really isn't. But it's not about who had the knife. It's about why and whether or not that was reasonable. Did he have a reason to do that? Or was he just out there to kill somebody? The state gets a lot of things wrong about this case. But it got one thing absolutely right. This is a specific intent case. But it's not specific intent to murder. You know that. You sat here through all of this. There was no specific intent to go out and murder. In order to believe that there was specific intent to murder Jimmy McGrath, you would have to believe that Mr. Valle was some sort of trained knife fighter who knew that by taking a 3-inch pocket knife and inserting it between the 6th and 7th intercostal, that he could strike directly into Mr. McGrath's heart. Now again, he's no criminal mastermind, and he's certainly no trained knife fighter. What he was a 16-year-old boy, down on the ground, getting stomped and kicked. And the numbers were overwhelming. Was it 15? Was it 20? Were they all focusing their attention on him at one point? Were they all focusing their attention on Tyler Da Silva? In that chaos, that's not a determination he could or had to make. None of us likes violence. We're not up here saying violence is okay. That's not part of the argument. But what we're saying and what the law says is that when you have a reason to believe that you need to defend yourself, that you have a right to do that and to use the force necessary. And that's what he did. And how do you know that that's what he did? Well, I guess if the state's now conceding that he got that knife during that exchange down on 36 Laurel Glen Drive, when we see those folks coming up, then the state should also have to concede the following. He had that knife in his pocket, and he didn't take it out when those folks came up. And he didn't take it out when he got sprayed in the face with WD-40 or PB Blaster. Forgive me, I have no idea what PB Blaster is, but I understand it's something that you could spray out from an aerosol can. And he didn't use it then either, despite having it right in his pocket. That's a lot of control for a person that they want you to believe is basically a homicidal maniac. He can't be both. Now, when he's down on the ground, you may recall Ryan Hines telling you, again, I didn't feel like he was aiming at you. What else did he tell you about his position? Do you remember? You could see his arm doing this thing, but it looked like his other arm and his bicep were somehow stuck under him or pinned beneath him. Sure, because he told you he was in the fetal position down on the ground before he was able to get that knife out and start using it. And he had not just Ryan Hines on him, but all those other boys. You can see it in the video. You've got a couple different versions of that video, and I gave you Defense Exhibit B, and I'd ask you to use it, a frame by frame that you can go through as fast, as slow, focus in on a single frame, and you can see that there are two groups that peel off, that there are two folks that are wearing very similar outfits, and those outfits look very much like the lighter bottoms, dark blue top, some graphic on the back, the Jimmy McGrath, and Tommy Connery admitted to having been wearing that night. And you can see in some of those frames feet attached to those figures, kicking a figure down on the ground that is clearly not Tyler Da Silva because he's being subjected to a separate beating over to the left. And you heard about how there were two fights that developed, and that one goes down over to the right and one's going on over to the left. And think about what he's facing at that moment when he's down on the ground, because that's what self-defense requires. Not us sitting here later in the cool hindsight of this room, the ability to say, this, look at that. No, it's at that moment when you're 16 years old and you're down on the ground and you're facing the entire Shelton High School football team that's pissed off and they already know about the fight at 5 Lazy Brook, right? You heard testimony. They got there and everybody was already asking them about it. One of the first persons that came up to ask Ryan Hines about it was Jimmy McGrath. Griffin Marcinzik told you, Jimmy McGrath's one of the toughest kids I knew. There was already a building fury in that basement. They didn't know about that. This bunch of idiots are in the car. They just got added to a group chat. People are talking shit to them, as they said. People that they claim they knew on social. Can we all agree that if you think you know somebody on social, you don't know that person? I think you guys have all gleaned what a Luddite I am by my inability to work this contraption over here. Knowing somebody on social, you just don't know anything about that person. These were all strangers, at least to my client. Now, you know they're not all strangers to Tyler Da Silva. Right? He told you about growing up with some of them. He told you about they knew cousins and things of this nature. And here they are, texting in the group chat, talking shit, and he says he thought it would be funny to tell them to come over to Trumbull High School because they were gonna leave Trumbull High School, and if they showed up, they'd be gone. And then he told you, I saw a picture that got sent on the group chat, and I realized, oh man, I know some of these kids, and he left. He left the group chat. There's Tyler Da Silva, Jack Snyder in the front seat. And they're still going back and forth, and they're still going at it. Jack Snyder and Griffin Marcinzik are really going at it, right? Griffin Marcinzik is taking photos of the car out front saying, sitting ducks. That's what he was facing when he's down on the ground. Not you and I coming up around him and saying, what's going on here, my friend? Perhaps you should not be here right now. This appears to be a bad idea. No, that's not what that video shows. And let's talk about the existence of that video. These kids were ready. They came out with their phones going. This was gonna be a trophy. Just like a hunter hanging a head up on the wall. Let's document this. Let's record this. Not, oh gosh, we don't want this to be going on. This seems a little too violent. Gentlemen, let the young man up. No, we're filming this thing. And we're celebrating. You remember Tanner Chanowski up on that stand? When I asked him, can you identify whose voice that is saying, yes, sir? That was me. That was you? And you're saying, yes, sir! Is that celebratory? I don't know what you mean, celebratory. I don't know. I don't know why I said it. Oh, I asked, did somebody ask you a question to which the answer was yes, sir? Is that what happened? No, I don't think so. No, I don't think so either. And again, how many times did these guys tell you something here that they admitted they hadn't told anyone before? And how often were they telling you, we were all doing something? Everybody just went. I couldn't see this and that and the other. But then on cross-examination, they would tell you, oh, well, you know, yeah, everyone was throwing something, but actually that was me that was throwing something. Everyone was screaming stuff, but actually that was me that was doing that. They wanted to minimize their involvement, generalize what they were doing, anonymize it, and scrub it clean so that they could come in here and tell you, we were just shocked to find this going on. You know that's not true. If you want to believe that, ask yourselves, why? Why do you want to believe that? Sympathy? Do you have any reason not to doubt that when they tell you that? These are people that are filming a beating, not just one. Ricky Fiola's filming too, right? We just don't have that film. Ricky Fiola's over there, he's got the camera out, he's doing this. You can see him in some of these freeze frames that they show you, right? He's like this, and you can almost kind of see when he turns over and he looks at the camera, and the light shines right in his eyes, and boop, you get that little red, and he's kind of like, oh shit, right? Oh, I didn't realize somebody else would be filming me filming. And then he goes, and what does he do with that? He goes and gives it right to the cops, right? Nope. He takes it and he shows it to some girls that were watching the thing go on. He wants to show them Tyler Da Silva getting beat because he thought one of the girls would like seeing Tyler get, and then he kind of drifted off, right? And I asked him, can you finish that for us? And he couldn't remember what it was that he wanted to show him for that. There's no reason to believe that those folks were going to stop unless they were made to stop. And if you tell yourself that there's a reason to believe that they were going to stop unless they were made to stop, and if somebody back in that jury room tells you, no, he didn't have to do that. They were just going to stop and then let him up. Well, what's the reason to believe that? I'm asking, what's the reason to believe that? What's the psychology of a mob? What's the psychology of 18 to 20 boys and men? Don't forget, this is a boy at that time. Some of those folks there were men. They had already graduated, right? They told you. Taylor Capella told us. It was mostly older kids there that night. What is the psychology of a mob? The problem with the mob is not what they do as much as what they might do. Because you don't know what they might do. So when you're down on the ground, you're getting kicked and punched and stomped. And again, we know there's at least 15 to 20 people there. It doesn't matter what these witnesses got up here and told us on the stand as far as saying, no, it was just a one-on-one, or maybe it was two of them talking with them. That's just simply unbelievable based on what we see there and what's going on that video. And we heard a little bit from some of the witnesses trying to tell us Raul's there on the lawn beside Tyler Da Silva. They're facing this big group of Shelton High football players that have started to circle them. He's not got the knife out, but he's gonna pull back like he's cocked and ready to punch somebody. And who was that supposed to be? Ty Woods? You didn't hear Ty Woods tell you that, did you? No. You didn't hear a thing from Ty Woods. You heard the people that are trying to protect themselves from what they did tell you that that's why Tyler Rich just had to haul off, even though he was over here talking to Tyler Da Silva, and punch Mr. Valle, who again still had not pulled out a knife, even though he's got it in his pocket. Didn't even pull it out to say, hey, whoa guys, this is looking a little dangerous here. I think maybe you should all know, back off. No, at that point, Tyler Da Silva's still thinking he's gonna make peace because he knows somebody's cousins. They know his cousins. Ricky Fiola and Tanner Chanowski are proof that everybody there knew what they were planning to do because they had their cameras ready to go. So those are the kind of folks that are kicking and stomping and punching Tyler Da Silva and Mr. Valle while they're down on the ground. And the first three folks that get stabbed, look at their wounds. Again, Faison Teal. He told you, well, I was sort of over on the side, and then I came in and I started getting in a few, what did he call them? Light stomps? Medium stomps? You ever been medium stomped? Anybody? What's a medium stomp? A stomp is a stomp. A stomp is somebody down on the ground. You don't stomp somebody who's standing up, do you? No. No more than you stab somebody in the legs unless you're down on the ground. Look at those wounds. One to the back of the leg. A couple to the front. Those are wounds that you give somebody when you're down on the ground. You don't bend down and give a couple here and a little there and let me get one in the back. It's just not how that happens. It happens fast because you're frightened and you're panicked and you're scared and you have a reason to believe that you've got to do that because nothing else is stopping them. In fact, you heard Mr. Valle. It scared him even more after he had to do that because it didn't stop. And you've got Ryan Hines. Look at his injuries. One to the ribs. What, when you're over top of him? When you're punching him in the face? Then further down on the side, and finally one down on the hip flank area. Again, what did he do? Mr. Valle was standing with him and went, one here, one here, one here, and then one there. It makes no sense. It's not the way this happened. It's not the way self-defense happens. Again, it's not complicated. Doesn't mean it's not hard. Doesn't mean it's not difficult, the decision that you have to make. But it is not complicated. It is simple. He's down on the ground. He's getting beaten. He's getting stomped. The same thing is happening to his friend. Nothing is telling them that that's going to end unless he makes it stop. So with his arm pinned behind him while he's getting stomped and kicked, boom, Ryan Hines. Tommy Connor, he tells you, he comes over and separates them, right? And he takes his place. Takes his place over top of him, pounding him on him? No, he's over there as well, getting in his kicks. His leg gets stuck, gets the side, the back, right? Now Ryan Hines tells you, after he got stabbed, that was it. He had nothing to do with what happened to Tyler Da Silva. You know that's not true because you saw that video. You saw that green hoodie, black shorts with the white trim right over there on top of Tyler Da Silva, kicking him and stomping him with the rest of the group. Part of the state's argument here is simple. Who are you going to believe? Our witnesses or your lion eyes? Look at the video. Watch it, and you will see there are two groups here. You will see one group breaks off. That's the group that is beating on Mr. Valle, and then you can see them shove him into the road. He walks to the car. Thank goodness, at that point, Tanner Chernowski was filming. Because what do we see? Camera pans over. He's looking. What's he looking at? He's looking at where Mr. Valle is. Mr. Valle's by the car. He opens the door briefly. You see the light come on inside, the interior light. And then you see his head go just like this. Right? And we can see the side of his face. We see the profile. And you can almost hear the wheels clicking inside Tanner Chernowski's mind. It's like, what's he looking at? Now you see the camera pan again. Boom. What does that camera pan right to? Tyler Da Silva on the ground, surrounded, getting pounded on by a number of kids, right? Kids that are saying, yeah, come on, get some. Who wants a piece of this? Yes, sir. That's what's going on. Any indication those kids are gonna just stop that at that point? No. Not a single reason to believe that they're gonna stop. They didn't stop with my client until he had used that knife. And they gave him no reason to think that they were gonna until he used that knife. That knife was a tool. It was the only tool that he had available to him to survive that night. That was the specific intent that he had. The state's charged specific intent crimes. Again, they're right about specific intent, but it's not specific intent to murder. It's not specific intent to assault. It's specific intent to survive. Because he had no reason to believe that they were gonna just let him, that that was gonna stop. They were intent on pummeling him into unconsciousness at best, serious physical harm, almost certainly, and no way to know whether or not that was gonna stop until he was dead. Just not. If you want to believe otherwise, ask yourself why. You're going to get an instruction on implicit bias. Is there something about the way my client looks, the way I am, that makes you think he's any less believable than those kids? That he deserves to have self-defense available to him any less than any one of us? That those kids, if they were down in that same position, wouldn't have done that exact same thing? Would it change your mind if he'd had a screwdriver with a 3-inch shaft in his pocket and that he pulled that out and used it? He'd have the same wounds, stabs and punctures. This is what self-defense looks like. Most of us have never had to think about that before, right? What does self-defense look like? I don't know. Maybe I saw it in a movie or something. There's no manual for self-defense. When you're down on the ground, there's no handbook that you can pull out and be like, page 4, getting stomped by group of, how many of you are here? Okay. Doesn't work like that. The law doesn't require you to go through that. Because if it did, you'd be dead. Maybe that's something that you've never thought about with the law. But I asked you guys, I know I did. Can you follow the law even if you don't like it? And I probably gave you some ridiculous example, like, have you ever heard the song, I Can't Drive 55? Right? There's a guy who doesn't like the speed limit rules, and he says he can't follow them. Well, this is a lot more serious than that, right? This is, can you follow the law even if you don't like the fact that somebody died? But the law is, you just have to make a reasonable choice. Did he have a reason to do what he did? Yes. Do you have any reason to doubt that? What is it? Because Tyler Da Silva told you that the fight was over when he got back over there? You saw Tyler Da Silva in that video. He didn't think the fight was over. He's in the street, hitching up his pants, facing back towards the group. And we can't see Raul at that point. Tanner's perspective is over here. We can see Jimmy McGrath a little bit on the side. And you heard Mr. Valle tell you. They were forming a semicircle. They were forming a horseshoe. And I asked all of those witnesses who watched that video, where did those kids go? Where was Charlie Connery coming from? Followed by 1, 2, 3, 4, 5 kids. Who were those kids that were following him? One of them was Matthew Lockridge. One of them was Jimmy McGrath. Where were they coming from? Watch that video. Use the frame by frame. Go through that part closely. You'll see exactly where they were coming from. They're coming from just having been involved with the fight with Lito that shoved him out into the grass, out into the street. That's exactly where they're coming from. Now, he didn't have time to identify anybody. He didn't know Jimmy McGrath. That's probably the tragedy, the most tragic thing of this whole thing. These kids are practically strangers, at least when it comes to Mr. Valle, as to all of them. And with a stranger, you can't know. What is that person going to do? You have to make your decisions based on the information that they're giving you at that moment. Again, what's the information that he's got? These are kids that are going to attack the car. These are kids that are going to stomp, kick, punch, gang up on, film it, record it. For what? I asked Tanner Chernowski, why are you recording this? Oh, I don't know. I just do that. And then at some point he admitted to collect memories. He thought this was going to be a memory that he wanted to keep before he knew what the tragic outcome was. But when he thought it was just a beating and an assault that was going to go on, yeah, that was a memory he wanted to collect. That's who Tanner Chernowski is. That's who these other kids were. Now, some of you might be thinking, well, when he comes back onto the grass and he passes by Tyler Da Silva, at that point, I can't see any of those other kids that are there. I just see Tyler, and then I see a little bit of Jimmy. Well, you see a little bit more than that. Right? See that hand? Remember that hand down here around the back on Jimmy? It's not his hand. It's Matt Lockovich's hand. Because they're side by side. Because they are part of a semicircle baseball. This is a group that has been acting as a group the entire time. You're telling me all of a sudden this group has decided, oh, let's split up, let's single out. No. And in fact, you can see in the video, across the way, there's another person on the other side of Mr. Valle. He's got on a dark top and there's some sort of white lettering across the top. You may remember I was trying to point that out. You're going to have that evidence. Take a look at it. And ask yourself about perspective, right? Because when we're looking at things one way, we can see it like this, and these things appear to be very distant and far apart. But if I shift over here, now it looks like something else is in front. And ask yourself, wait a second. He steps into that place. These kids are all around him. They don't just disappear. And you say, okay, well, hold on. Charlie Connery's yelling, he's got a knife, he's got a knife. These kids are all backing up, right? Makes perfect sense, right? Thank you, Charlie. You solved that one for us. I think he did, inadvertently. Do you tell somebody who's running out of a house fire, fire, fire! I gotta warn you about the fire that you're running away from. No, you don't. You warn somebody about a danger that they are running into. And that's exactly what was happening here. He's got a knife, he's got a knife. Guys, don't go rush him. You need to back up. That's who you warn. You don't call off people that are already calling themselves off. Again, that just doesn't make sense. And you don't have to believe those witnesses just because it's their friend who died. You don't. And you shouldn't. And you wouldn't under any other circumstances. Some of you have experience doing workplace investigations. You know this is way more serious. These stakes are so high. Why are you going to believe these witnesses and this evidence under circumstances like this, when you wouldn't believe these folks, knowing what you know about them, their selective memory, their efforts to minimize and generalize and anonymize, not put themselves or their friends in any danger? Lay it all on him. So your duty is to look at this situation, the circumstances that my client faced as they were at that time. It's at least 20 versus 2. It's at least that. Could have been more. Some of these folks told you, oh, well, there's people watching. They're just sitting. They're just watching. Okay. If you want to believe that, there's probably nothing I can tell you or should even argue to you. These folks had sprayed WD-40 in his face. These folks, 20 versus 2. That's 40 fists, 40 feet and legs. There's nothing that says the force he uses to defend himself under those circumstances has got to be identical. Just because they have fists and feet doesn't mean he can only punch and kick back. That's not what self-defense requires. It simply requires reasonable. Is it reasonable to use a 3-inch pocket knife that you didn't bring, but that you have in your pocket because your friend gave it to you? Under those circumstances? Of course it is. Look at these wounds. Jimmy McGrath, 1 wound. That's it. He's not trying to stab him over and over and over. steps into this situation. Look at the amount of time between the time he steps onto the grass. And again, perspective. They want to try and tell you that that kid on the far side of him is not lined up with Mr. Valley. Look at the grass underneath their feet. Valley's on the grass. That kid's on the grass too. The line of the curve goes just like this. You know about horizon and perspective? They're almost side by side, those two kids. The other kids haven't gone anywhere. It's wet. You remember me asking all these kids, is it dark, wet, rainy, misty? I don't remember. You can see it in the video. You can see rain beating on the windows of the cars. Of course it's wet. And you heard Taylor Capella tell us he came onto the grass and he slipped. He spun around. And Mr. Valley told you he got punched. Somebody swung at him. Did you see Matt Lockovich's hand on Jimmy's back? Then all of a sudden it's gone. You can infer what happened there. Matt Lockovich takes a swing at him, and Mr. Valley told you, I just swung, I put everything I had into it, I was terrified. These kids hadn't stopped before when they were stomping me and I had to use that. They weren't stopping now. Did he have a safe retreat that he could completely and safely retreat? Of course not. Last time that he had tried to get up, these kids tackled him and went down again. And here they were coming again. And we know they were coming again because we hear them being warned. He's got a knife. He's got a knife. Again, you're not telling that to somebody who's not walking towards that danger you're trying to walk them off, who's not rushing towards that person once again. Mr. McGrath is holding the edge. These are all football players, right? They know what it means to hold the edge. He's holding the edge of that horseshoe in that semicircle. He is a threat just as much as anybody else in that mob at that point. Those are the circumstances that Mr. Valley was facing. That's what you have to judge him on. And if you want to believe these kids, look, you've heard about consciousness of guilt, right? Why have we heard this evidence about consciousness of guilt? It doesn't change anything about what happened down there on the ground at that point. It's just another effort to make my client look like some sort of criminal mastermind. He knew to go out and throw the knife into the woods. Well, let's talk about that. Who told us that that's what happened? Only one person. Jack Snyder. When he's in here singing for his supper, the jailhouse keys ringing in his ear, he's trying to give you something, trying to give the state something, to believe him. Oh, they haven't found a knife. I'll tell him he threw the knife down at the end of Adams, in the cul-de-sac. And then Shelton PD, Detective Bango tells you, oh, we went out, we looked for the knife, we couldn't find it. No knife. I guess that means Jack Snyder must be true. I guess Jack Snyder must be telling us the truth now about this. Tyler DeSilva doesn't tell you anything about that. He's in the car, it stops, nearly hits his head on the back seat. He's screaming at Jack about something. 1 or 2 seconds later, Mr. Valley hops back in the car. Mr. Valley told you. I got out of the car, I was feeling some pain, I looked at my ribs. He didn't tell you that he had the knife or that he did something with it. He told you he lost that knife, right? And he told you he lost that knife as he was running back, trips and falls, and what's he got on his hands? You've seen it. He's got 2 big, nasty strawberries on the heels, palms of his hands, exactly like somebody would have when they fell to the asphalt. Like it looks like road rash. And he lost the knife at that point. Do you have any more reason to believe Jack Snyder about anything, let alone that? Of course not. Ask yourself, if you want to believe him, why? Why do I want to believe Jack Snyder so badly? He's not giving you any reason to believe him. The text messages. Again, here's my client, the criminal mastermind, conscious of guilt. So he's texting with his girlfriend, who's also, no, she's 17. He's 16, she's 17. They're texting back and forth like he's gonna convince her that he wasn't there? That doesn't make any sense. He was panicked. He was still scared. He had no idea what had just happened. Look what he'd just been through. He's not gonna convince her that I wasn't there. And then he goes to Florida. He's 16. He doesn't go to Florida because he's trying to get away from things and he knows that he can go down there and escape. I don't even know if you can get on a flight when you're only 16 years old. But he gets on that flight because that's what his parents told him to do. And that's what you do when you're 16. When your parents tell you we're going to Florida. It's not a mastermind move on his part. It's just trying to make him look bad. He doesn't need any help looking bad, okay? Again, bless his heart, there was a whole lot of stupid going around that night. That's my client that I'm talking about. Mr. Valle is no different than any of these other kids. And if you're telling yourself for some reason that you think that he is, ask yourself why. Look at the situation all these kids were in that night. How did they get there? These kids at 43 Laurel Glen Drive were like torches. My client and his friends, they were like straw. Throw those torches in there, put them all together. There's absolutely no way to know what is going to happen as that wildfire starts to catch and goes round on the front lawn of 43 Laurel Glen Drive. But he certainly knew as he was down on the ground that folks weren't stopping with the stomping, they weren't stopping with the kicking and the punching. So he used that knife, a tool to survive. If you're down in the bottom of a hole, dirt's being shoved on top of you, you're gonna use a shovel to climb your way out. That's what he was doing that night. You have every reason to believe that.
Or a little bit over, so if you wrap it up.
Thank you, Your Honor. Folks, I'm not gonna apologize for taking up a little bit more time. I do wanna thank you for listening. I hope you will look at that evidence. I hope you will take your time with it. I hope you will all understand this is probably the most important thing you've ever been asked to do in your lives. And I will tell you that the law requires you, despite the tragic ending in this case, the law requires you to find my client not guilty. Thank you.
Thank you, Attorney Smith. I am going to go ahead and take a quick break before we continue on with the state's argument. So we'll stand in recess until 12:15. We'll come back at 12:15. 12:15.
Your eyes closed in recess. Back in session, the Honorable Judge Murphy presiding. Afternoon, Your Honor.
Good afternoon, thank you.
Good afternoon, Your
You may
Honor.
be seated. Thank you, sir. The state needs a few extra minutes.
I'm sorry, Your Honor?
The state needs a few extra minutes on your closing.
That's fine, Your Honor.
Welcome back, ladies and gentlemen. Counsel, thank you. Please stipulate to the return order.
Stay or stipulate? It's been stipulated, Your Honor.
I would invite the state back up to enter.
Thank you, Your Honor. Good afternoon. This is my second opportunity to address all of you. It's funny that I'm listening to counsel's argument about there was a lot of Tyler DeSilva, Jack Snyder in there. This case does not rise and fall with Tyler DeSilva and Jack Snyder. The warrant was signed, you heard from Detective Bango, on Monday the 16th. So the warrant was signed, there was enough probable cause at that point, and the investigation was still unfolding. But there was enough to arrest the defendant for what he did that night. Tyler DeSilva and Jack Snyder approached us 6 months later because they had information. And they want you to discredit everything that Tyler DeSilva and Jack Snyder said in court. But you have to look at it. Remember when during voir dire, I asked all of you, how do you determine credibility? Are you just gonna sit there and look and hear, you listen to what they have to say, what's their demeanor? But isn't it, use your common sense, how does what one witness say, how does it marry up to other witnesses' testimony in the entire case? Tyler DeSilva and Jack Snyder are not the only people that heard the defendant ask for the knife that night. Keenan Frasick did, Demetrius Arfanis did, Mackenzie Traficante heard somebody asking for a knife while she was walking away. There are other people that heard these things. So again, whether or not you're ready to just discredit them because they have an immunity agreement with the state of Connecticut, I suggest to you, see how the information they've provided to you in this case marries up with the rest of the case. And I would agree with the defense that there was a lot of stupidity that night, absolutely. But the bottom line is you can't bring a knife to a fist fight. You just can't. Look at the defendant's injuries days after the incident. He's not completely beat up. It's because he took the knife out immediately and started stabbing people. You would think he would have huge contusions all over his head, and he didn't even go to the hospital. I would submit if he was that badly beat up and the only way out was just to, I had to fight for my life. But the physical evidence does not show that. And there was testimony, his arms pinned under his body. How did he get the knife out with one hand and open it up with one hand? I would submit that's next to impossible unless you're a pro at it. I think the more likely thing that you can infer from what happened is that he took the knife out of his pocket while he was involved in the fight immediately and opened it up and started stabbing people. He wasn't on the ground like they would have you believe. He went after Tommy Connery. He stabbed Ryan Hines in the chest. It's just not reasonable to bring a knife to a fist fight. He went there looking for trouble. That's the bottom line. Because if he doesn't go back, none of this happens. But he went back. Imagine if he didn't go back with a knife, it would have just been a fist fight. That's all. But he went back with a weapon. You can't use more force than what's being used against you. And the defense would have you believe that being punched is deadly force. It's just simply not true. By the way, they want you to discredit everybody that has testified in this case. This is not a whodunit, and they agree it's not a whodunit. right? He used that the defense attorney used that parking lot example. I was actually thinking about this during the break. You know, the kids that testified, they saw what happened, right? It was chaotic, but they saw what happened. And when they go and they give a statement to the police, you know, were they asked who was to the right of you, who was to the left of you? Probably not. Did they know at the time? Maybe. But now it's 3 years later, right? So it's kind of like a situation where you're in a parking lot and you park your car. Now, all of you came here and you parked your car. Did you look to the right? Did you notice what color the car was next to you? Maybe some of you did. Maybe some of you didn't. But you know you parked next to a car, right? Now imagine that happening and then you see somebody being chased in the parking lot and getting stabbed with a knife, right? Now that's a horrific event that you've just witnessed. And you give a statement to the police, right? And you see, you're not gonna say to yourself, well, I parked next to the red car. Maybe you remember that at the time, so now fast forward 3 years later, I guarantee each and every one of you would recall that horrific event happening. But if you got on the stand and I said, well, what color was the car to the right of you? I can't recall. What car was the car to the left of you? I can't recall. Do you know if there were cars next to you? Yeah, I know there were cars next to me. I just don't recall what color. So the reality is the color of the car or the person that was standing next to anybody necessarily in and around that area, in this fight, this chaotic scene, is that important in the grand scheme of things, right? Does it make a fact and evidence more or less probable? Probably not, right? Because listen, there were a lot of people around, a lot of people were watching. There was 2 or 3 kids fighting at any given time. Right, we've seen that, we've seen the video. But does it really make a difference if, you know, Taylor Capella told she was standing next to who? Michaela Holt, right? She remembered her. Maybe there was somebody else next to her she can't recall. Tommy Connery was standing in the driveway at any given time when the car first arrived. Yeah, I knew I was there, I was talking to people, I just can't remember exactly who I was talking to. But does that really matter in the grand scheme of things when we know the car arrived at 43 Laurel Glen? There was this confrontation, the car was shook, the car was hit, and they took off. And according to people inside the car, it was scary, we didn't want to be there, and we wanted to get out of there. And the defendant told you that. Again, assess his credibility, because when he's down the street, he arms himself with a knife and comes back. If you're really that scared, why would you go back and confront 30 kids who just shook the car? I mean, that makes no sense to me. So, I mean, look, the defendant was angry. We don't know why he was angry. It's because of the car. We've heard testimony about that. It's because, you know, these kids really messed up the car and he was pissed off, and it was almost like they one-upped him. He had already had one up on Ryan Hines back on Lazy Brook because he tuned him up with the helmet after he sucker punched him from behind. But now that they disrespected Jack Snyder's car, let's go back. Let's go back. If things go sideways, guess what? I got a plan B. That was his plan. Might have been a stupid plan, but that's what happened. That's the bottom line. This is not something that happened, you know, I mean, I would say instantaneously. As soon as he gets hit, he takes the knife out. He's not waiting to get pounded on. There's no way. If he was getting pounded on the way the defense suggests he was, he would have more injuries that we would have seen after the fact. And he simply did not. And by the way, the defendant testified when he was running out of there after he stabbed McGrath in the chest, he dropped the knife. The cops looked for the knife all in that area. They couldn't find the knife. They actually walked up and down the street. They held the area. They looked for the knife the next day. No knife. And the information that Jack Snyder and Tyler DeSilva gave us, right? We didn't know where the knife came from. We knew the defendant had a knife. We didn't know how he had the knife or where it came from. Jack Snyder gave us that information. He came to us. We didn't go to him. But even if you take DeSilva and Snyder out of it, it's still the defendant going back to 43 Laurel Glen with a knife. There were people in his car that he went to high school with that heard him ask for a knife. He went there, he got out of the car, he went in, and when he provoked the fight and instigated the fight, and it started, he took it out and started stabbing kids. Because that's what he wanted to do. And then once he was able to get out of there, he went back in for more. And they have to have you believe that, oh, he was being approached or surrounded when he came back into the fold. He has a duty to retreat. You can't come back into a fist fight with a knife. It's just not reasonable. It's not reasonable. Even if you believe that that self-defense applies to the first 3 kids that are stabbed, even if you believe that. It certainly does not apply to Mr. McGrath. Because again, self-defense is not retaliatory. It's not punitive, it's defensive. You can't do things like this and then turn around and claim self-defense. He came back from the car. Charlie yelled, he's got a knife. And within seconds, he turned around and stabbed McGrath in the chest. They want to have you believe that he slipped. He slipped. It was a purposeful stab in the chest, right? So again, when we're talking about intent, specific intent, the areas of where the wounds were inflicted, right? The number of wounds inflicted, the defendant's manner and how he conducted himself that night, both at Lazy Brook and later that night. He did not have to go back to that house. It's as simple as that. He did not have to go back. But if he was going back, he was going back with a plan B. That's as simple as that. And that conduct cannot be excused. It's a horrific event. It's terrible. It's a tragedy. That cannot happen. Because if that happens all the time, then this is a very different world we live in. And I asked him on a cross-examination, when you got out of there and you left and you went home, after you texted Mackenzie, you didn't call the cops at that point, did you? Nope. You went to Florida, right? Yep. Did you call the cops when you were in Florida? Nope. After you learned the severity of the situation, did you call the cops and tell them, hey, this is what happened, I was pummeled, I was acting in self-defense? Nope. So again, I would submit to you that, yeah, he knew what he was doing, and as soon as he stabbed those kids, and he told Jack, and they got out of there, and they went down to Adams Drive, and he got rid of the knife. Why are we getting rid of the knife? Call the cops. This just happened. It's horrific, but this is what, got rid of the knife, got rid of the evidence. Tells his girlfriend I wasn't there, didn't want to put anything in writing, God forbid. Because if he said, yeah, you know what, I was really getting pummeled, I had to stab those kids to get out of there, I was really fighting for my life. Didn't say that in the text, just said, nope, I wasn't there, it wasn't me, I don't know what you're talking about. You know I wasn't there. And then he told Tyler De Silva subsequent to that he messed up. He knew. He knew. The judge is going to give you, the self-defense instruction. And again, it's only justified when a person reasonably believes that such force is necessary. Reasonably believes. The first thing he didn't do is he didn't punch back, he didn't kick. He grabbed that knife. Again, you're going to hear the judge instruct that a person must not use more force than he reasonably believes is necessary. I would submit on that night he used more force than was reasonably necessary. And state submits that we've proven that beyond a reasonable doubt. We also submit that he provoked the fight. You're going to hear some disqualifiers. If you believe the state has proven the disqualifiers, one or all of them, doesn't matter. If you believe we've proven those disqualifiers beyond a reasonable doubt, then he cannot avail himself of the self-defense claim. So under provocation, you're going to hear the judge instruct that a circumstance under which a person is not justified in using any degree of physical force in self-defense against another person is when he provokes the other person to use physical force against him. The defendant must have specifically intended to provoke another into using physical force and then use force to defend himself from the ensuing force that he provoked that person to use against him. You're also going to hear about the initial aggressor. The instruction that with regards to that is another circumstance under which a person is not justified in using any degree of physical force in self-defense against another is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using physical force. He also has a duty to retreat. You're going to be instructed that two conditions must be met. A complete safe retreat is available to him, and he knows he can avoid the necessity of using deadly physical force by making a complete safe retreat. Self-defense cannot be retaliatory. It must be defensive, it's not punitive. You know, it's again, if you look at the whole, if you look at everybody's testimony, they would need you to disbelieve everybody's testimony in this case for you to not find that the state has proven this case beyond a reasonable doubt. If you looked at Jack Snyder and Tyler Silva, took them out of it, and just listened to everybody else who testified, I would submit that there is enough, more than enough evidence to determine that this defendant brought a knife to a house he shouldn't have been at. And he used that knife. So he shouldn't have. And after he used it, he went back in and he stabbed McGrath for no good reason. But I would submit that he formed the intent to kill him when he turned to him and lunged at him and stabbed him in the chest. You heard the testimony of the doctors, of the medical examiner. These were not slash wounds, these were puncture wounds, purposeful puncture wounds. You know, the fight lasted about 30 seconds. You heard evidence of that, 17 of which it was video recorded. I know the defense counsel wants to point out that McGrath was involved in some of it. Unclear. You're the judges of that. But even if he was, like I said before in my opening remarks, self-defense cannot be retaliatory. You can't come back and say, well, listen, man, you were pushing me into the road. Sorry, I'm going to stab you. You can't do that. I mean, what kind of world do we live in? You know, yeah, it's not right that there's fist fights. It happens. But, I mean, look, Tyler Da Silva was getting beat up, but he wasn't getting completely demolished. I mean, at some point, they threw him out in the street, and they said, get out of here. It was over. And, you know, in the Ryan Hines, Faison Teal, Tommy Connor, they came in and they told you what their part was in the whole situation, right? Tommy Connery, I would submit, there's no self-defense claim against him. He was trying to get in there and breaking things up, pushing him away. Why did he deserve to get stabbed? And I would submit Ryan Hines, yeah. Ryan Hines said, I hit him, punched him a couple times, but that's his fist. It's not a knife. If Ryan Hines had a weapon, it would be a different story. If Faison Teal had a weapon, this would be a different story. If Tommy Connery had a weapon, this would be a different story. And if Jimmy McGrath had a weapon, this would have been a different story. But the bottom line is you can't escalate the fight. And that's exactly what the defendant did. Counsel indicated on his closing argument that Tyler Rich wanted him on the lawn. That's simply not true. And we have evidence of that down at 36 Laurel Glen. They ran down there, they're arguing back and forth, things are being thrown, but there's no physical altercation. Why would you, let's wait and see if they come back. Let's fight on the lawn. I mean, just have the fight down the street. They didn't fight down the street. That's the whole point. They wanted them out of here. Again, the judge is going to instruct you on what specific intent is. And no, there's no time, no particular time necessary, no length of time necessary to form the intent. I know that counsel, did he wake up in the morning? Yeah, I'm going to go kill somebody, stab some kids. Of course not. Of course not. But if that were the case, if we had to prove that somebody woke up in the morning saying, I'm going to go stab people or shoot people or kill people, then we would never be able to prosecute anybody, because that's a tough thing to prove. And that's the point, because it's the conduct at the time that it happens, right? That's how you can infer what his intent was. He created this specific intent when he decided to take out that knife and escalate the fight and stab people. And you heard everybody testify. I think I asked every person that testified that, when you were involved in the fight, did you have a weapon? What did you witness about the fight? Did you see anybody with weapons? Nobody had weapons there. It was a high school fight. A high school fight that the defendant escalated. And the interesting thing is, defense counsel didn't really spend much time on Taylor Capella and Charlie Connery. Those are the two individuals that actually saw the defendant stab McGrath, right? turned to McGrath and lunged at her. You know, who was Charlie standing next to? Do you think Charlie wasn't, you know, a lot of these kids, they were kids at the time. Their memories maybe have faded a bit. I don't recall exactly where, you know, Ricky Fiola was at any particular time. I don't recall if I was in the basement, on top of the basement, outside the basement. But the story is the same. The horrific event that is etched in their minds forever is the same. They recall this defendant, who had no right to be there, come back to that house and stab 4 of their friends. This is not about protecting people. They got on the stand. Yeah, we were underage drinking. Yeah, there was a fight. You know, people were punching people, and it wasn't right. Sure. But who were they protecting? Who were they protecting? They just came in here and told their story from their perspective. And does it mean that because one person's perspective as to where they were standing or who they were standing with, and the other person doesn't remember them standing next to that person, does that mean that it's a lie, as the defense would have you believe? I would submit no. Because if you don't recall sitting next to each other a year from now, but you recall me arguing to you and the defense attorney arguing to you, that's all that matters, right? Because it's what you're perceiving here, not really in your periphery necessarily. I mean, you may remember it, but does that matter is the question. Does it matter who was standing next to you at any particular time? And the defense attorney wants you to ask yourself, does a lot of it make sense? And the thing that I would submit to you that doesn't make any sense at all is if you were truly scared of the 10 to 12 to 15 to 20 kids that just rocked the car and threw stuff at the car, if you were panicked, why would you go back and want to confront them? At the end of the day, that makes 0 sense. It makes 0 sense unless you had some courage in you, and you had some courage in you because you had a weapon. That's the only reason that would make sense. Because he went there, he had the intent to hurt somebody there, especially if the fight got physical. They want you to believe that the knife was the only tool that he could use to survive. I mean, he's not, you know, in the Amazon. This is a high school fight, fist fight. That wouldn't have happened, by the way, if he didn't go back. The only kids seriously injured here were Ryan, Faison, Tommy, and Jimmy. He didn't get seriously injured. You can't bring a weapon to a fist fight. You just can't do it. And to excuse this conduct would be, just wouldn't be right. Self-defense cannot be punitive. It has to be defensive. At the end of the day, that's what this case is about. And that's what they're hanging their hat on. They want you to find self-defense. Because they can't hide around the fact that the defendant brought a knife to a fist fight. That's, in a nutshell, that's what it is. So, you have a tough job, absolutely, because you have to look at every element of the charge. Did the state prove it beyond a reasonable doubt? Did we prove the specific intent to cause serious physical injury with a weapon with regards to Hines and Tommy Connery? Did we prove the specific intent to cause physical injury with a weapon for Faison Teal? And did we prove that the defendant had the specific intent to kill Jimmy McGrath and cause his death? I submit to you that if you look at the conduct of the defendant, bringing that knife back, he could have left the knife in the car. He could have not taken the knife from Jack. Think about that. But he didn't do that. He brought the knife with him. If you look at that conduct and you're questioning, well, what was his intent? I mean, you have the Laserbrook fight too. Didn't need to helmet Hines, but he did. He helmeted the kid and then got up there and told you a different story. I think after you look at all the evidence in this case, cold, hard look at the facts, we're confident that you're going to find the defendant guilty of the murder of Jimmy McGrath, assault in the first degree, for Ryan Hines, assault in the first degree for Tommy Connery, and assault in the second degree for Faison Teal. Thank you very much for your time.
Thank you, Attorney General. All right, ladies and gentlemen of the jury, yes, you have heard all the evidence that you are going to hear in the case, and you have heard closing arguments. However, you have not heard the court's instructions regarding the law that you are going to apply, the facts that you find in this case. As you are not yet at the position to discuss this case with anyone, including your fellow jurors, okay? So you do obviously still remain duty bound by the conduct of your juror's oath and the rules of jury conduct, so do not discuss this case with anyone, including your juror. Remember that the rules that I've gone over with you day to day. We are going to move into our lunch break. After our lunch break, I'm going to come back onto the bench, do a few administrative things, and then I am going to have you brought back into the courtroom. And at that time, I will provide those instructions to you, otherwise known as the jury charge. So enjoy your lunch, get a little bit of extra time here for lunch. You'll hear the charge. You'll hear from me after the charge, and at some point in time later today, I expect that you will begin your deliberations. However, now is not the time. Okay? Thank you so much. Have a good night. Court stands.
All rise. session of the Honorable Judge Preppy presiding. Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
You may be seated. Counsel, the court is prepared to charge in accordance with the jury charge that's been provided, which does reflect the changes that were discussed during the formal charging conference. The only additional change that's been made is adding some language regarding the actions of the lawyers during the trial, in addition to their statements, and just some typographical errors, maybe a comma here and there, grammatical things. That's about it. All right. So I am prepared to move forward on this. I intend to take a break during the charge because, unfortunately, this charge is a rather lengthy charge. So I do want to provide the jury a few minutes to stand up and stretch. It's going to be difficult for everyone to get through just sitting. So I will give them some time to do that. We'll take a quick break in between. Additionally, I had asked about an exhibit list going in with the jury during deliberations. So I will be asking you to take a look at that, make sure that you agree that there's nothing on the list that inaccurately represents the exhibit as an exhibit that provides concern to you one way or the other regarding whether or not that list should go in. So you'll have additional time to do that after the court's done charging. Is there anything that the court needs to address at this time?
No, Your Honor.
Not from the defense, Your Honor.
All right, very good. So I am going to go ahead and bring the jury in then. Thank you. I just want to, well, actually, give me one moment. I'm so sorry. I just want to address everyone in the courtroom. You're welcome to be here. There are some courts that close the doors, don't allow anyone in and out of the courtroom during the judge's charge to the jury. I do not do that. However, I am going to ask for your cooperation in staying and remaining in place during the court's charge to the jury. This is a very important part of the trial. This is the law that the jury has to apply to the facts they find. If you do have to leave the courtroom, I am going to ask you to respect the court and the process enough at this point in time to not return to the courtroom during the court's charge. I will be taking a break during the charge, okay? If it's an emergency that requires you to leave and you have to come back in, that's fine, but I am going to be asking the marshals to keep an eye on that, people coming in and out, okay? So if you have to leave, that's fine. Just please be cognizant of where we are in the proceedings if in fact you're attempting to come back in. I want the least amount of distraction to the jurors at this time. Thank you for your cooperation. All right, now we'll adjourn. Welcome back, ladies and gentlemen of the jury. Counsel, please stipulate to return of all.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right. So once again, if you brought in notepads, I am going to ask you to set them aside. This is the jury's instructions. So I am going to instruct you on the law that is to apply to the facts you find in this case. You will have a copy of the court's jury charge with you during the deliberations. This is going to be rather lengthy, so I do intend to give you a break during the course of my charge so that you can get up, stretch, use facilities, and sort of, get comfortable and be seated again for some period of time. So you have heard the evidence presented in this case. I am now going to instruct you as to the law that you are to apply in this case. During these instructions, I will, for the most part, be reading from prepared material. I do this so that I do not inadvertently give you incorrect instructions. So if I lose eye contact with you from time to time, please bear with me. The reading of these instructions, like I said earlier, is going to take some time. The function of the court and jury. It is exclusively the function of the court to state the rules of law that govern the case with instructions as to how you are to apply them. It is your obligation to accept the law as I stated. What I tell you, not what the attorneys tell you, is the law that you are to follow. If the law, as I give you, differs in any way from the claims of law made by counsel, dismiss from your minds what counsel have said to the extent it differs from what I tell you. You must follow all my instructions and not single out some and ignore others. They are all equally important. Also to note, in these instructions, the court does use the terms first count and count 1, second count and count 2, third count and count 3, fourth count and count 4, crimes and offenses, and information and substitute information interchangeably. You as jurors are the sole judges of the facts. It is your duty to find the facts. You are entitled in the course of evaluating the evidence to draw any and all inferences that you find reasonable and logical from the evidence you hear. You are to recollect and weigh the evidence and form your own conclusions as to what the ultimate facts are. You may not go outside the courtroom or the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or suspicion. And you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathy. You should not be influenced by my actions during the trial in ruling on motions or objections by counsel, or in comments to counsel, or in questions to witnesses, or in setting forth the law in these instructions. You are not to take my actions as any indication of my opinion as to how you should determine the questions of fact. If I asked any questions of witnesses, you must not assume that I hold an opinion on the matter to which my questions may relate. Remember that you, as jurors, are at liberty to disregard all comments or questions of the court and the witnesses' responses to those questions in arriving at your own findings of the facts. You must not take anything I said or did during the trial as indicating what I think the evidence or what your verdict should be. Any reference I make to the evidence is only for the purpose of clarification of some point of law or a point of illustration, or to refresh your recollection as a general nature of the testimony. I do not intend to emphasize any evidence I mention or limit your consideration to it. If I do not mention certain evidence, you will use the evidence from your recollection. If my recollection of the evidence does not comport with your recollection, then it is your recollection which must prevail, because you are the exclusive trier of the facts. The defendant justly relies upon you to consider carefully his claims, to consider carefully all the evidence, and to find him not guilty if the facts and the law require such a verdict. The defendant rightfully expects fair and just treatment at your hands. At the same time, the state of Connecticut and its people look to you to render a verdict of guilty if the facts and the law require such a verdict. The law prohibits the state's attorney or defense counsel from giving personal opinions as to whether the defendant is guilty or not guilty. During my instructions to you, I may repeat certain instructions. I apologize in advance. I do this for the purpose of organization. You are not to consider a repeated instruction more important than any other instruction. All instructions are equally important. Also, during my instructions, I may refer you to previous or subsequent instructions given. When I do this, I will identify it for you and direct you to the section to which I am referring. If there is an inconsistency in the number and the title of an instruction to which you are referred, it is the title of the instruction that shall be controlling in my reference to it. Presumption of innocence. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. This presumption of innocence is with the defendant when he was first presented for trial in this case. It continues with him throughout the trial unless and until such time as all evidence produced here in the orderly conduct of the case, considered in the light of these instructions of law and deliberated upon you in the jury room, satisfies you beyond a reasonable doubt that he is guilty. The presumption of innocence as to each crime charge and as to any lesser included offense as instructed by the court may be overcome only after the state introduces evidence that establishes the defendant's guilt beyond a reasonable doubt. If and when the presumption of innocence has been overcome by evidence proving beyond a reasonable doubt that the accused is guilty of a crime charge or any applicable lesser included offense as instructed by the court, then it is the sworn duty of the jury to enforce the law and render a guilty verdict. Burden of proof. The state has the burden of proving that the defendant is guilty of the crimes with which he is charged or a lesser included offense as instructed by the court. The defendant does not have to prove his innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute a crime charge or lesser included offense as instructed. Whether the burden of proof resting upon the state is sustained depends not on the number of witnesses nor on the quantity of testimony, but on the nature and quality of the testimony. Please bear in mind that one witness's testimony is sufficient to convict if it establishes all the elements of a crime beyond a reasonable doubt. Reasonable doubt. The meaning of reasonable doubt can be arrived at by emphasizing the word reasonable. It is not a surmise, a guess, or mere conjecture. It is not a doubt raised by anyone simply for the sake of raising a doubt. It is such a doubt as in serious affairs that concern you, you would heed. That is, such a doubt as would cause reasonable men and women to hesitate to act upon it in matters of importance. It is not hesitation springing from any feelings of pity or sympathy for the accused or any other person who might be affected by your decision. It is, in other words, a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that, after hearing all the evidence, if there is something in the evidence or lack of evidence that leaves in your minds as reasonable men and women a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and acquitted. Proof beyond a reasonable doubt is proof that precludes every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion. Evidence. The evidence from which you are to decide what the facts are consists of 1. The sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. 2. The exhibits that have been received into evidence as full exhibits, including any pictures, videos, or documents that have been marked as full exhibits. 3. Any facts that the court judicially noticed. And 4. Any stipulation of the parties. In reaching your verdict, you should consider all the testimony and full exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include 1. Arguments, statements, and questions by lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but it is not evidence. Likewise, any emotion, reenactment, or other actions displayed by counsel during this trial is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in the case or to appeal to your emotions. Also, attorneys have a duty to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it, and you are not to hold it against any party for making objections. During the course of the trial, you may have heard counsel stand up and make comments about questions made by opposing counsel. You are not to regard any comments that counsel may have made in your deliberations. Any comments on the propriety of questions are not proper for trial or your consideration and should not be used in your deliberations. Lastly, the questions the lawyers ask of witnesses are not evidence. It is the testimony of the witnesses in response to the attorney's questions that is evidence. 2. Testimony that has been excluded or stricken. If I have excluded certain testimony, you must follow my instruction to disregard the testimony. In effect, I'm telling you to do what may be difficult, but which you will have to do your best to accomplish, and that is to accept in your minds that such stricken testimony is not evidence and must not be considered in your deliberations. 3. Anything you may have seen or heard when the court was not in session. 4. Anything you may have seen or heard from any spectators during the trial. 5. The document called the substitute information which you will have with you at the time of your deliberations. The information is merely the formal manner of accusing a person of a crime to bring that person to trial. You must not consider the amended information as any evidence of the guilt of the defendant or draw any inference of guilt because he has been charged with crimes. You will note that each count in the information contains within it the alleged date and location of the offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of each offense, including identification of the defendant, beyond a reasonable doubt. Direct and circumstantial evidence. There are generally two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence, that is, evidence from which you could find that another fact exists even though it has not been proved directly. There is no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any particular evidence. Circumstantial evidence of an event is the testimony of witnesses as to the existence of certain facts or evidence or the happening of other events from which you may logically conclude that the event in question did happen. By way of example, let us assume that it is a December night and you're preparing to retire for the evening. You look out the window and you see it is snowing. You wake up the next morning, come to court, and testify that the night before it was snowing in the area of your house. That is direct evidence of the fact that it snowed the night before. You saw it, and you came to court and testified to that fact. Now assume that it is another December night, the weather is clear, there is no snow on the ground, and you retire for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come into court and you testify to those facts. The evidence that the night before there was no snow on the ground and the next morning there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that sometime during the night it snowed and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is determine the believability of the direct testimony given, the credibility of the witness. With circumstantial evidence, you must first determine the credibility of the witness or witnesses and decide whether the facts testified to did exist. Then you must decide whether the happenings of those events or the existence of those facts leads logically to the conclusion that other events occurred or other facts exist, and ultimately whether the crimes alleged were committed by the accused. There is no reason to be prejudiced against evidence simply because it is circumstantial evidence. You make decisions based on circumstantial evidence in the everyday affairs of life. There is no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof by circumstantial evidence may be as conclusive as would be the testimony of witnesses speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of another fact or set of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in light of reason, experience, and common sense. Redacted exhibits. If there are exhibits that have been accepted into evidence as redacted versions of the original, please note that these redactions were made by way of agreement by counsel or by order of the court, and you must not speculate as to why the information was redacted or what was redacted. Redacted information is not evidence, and as indicated earlier, you may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or speculation. Credibility. In deciding what the facts are, you must consider all the evidence. In doing this, you must decide which testimony to believe and which testimony not to believe. You may believe all, none, or any part of any witness's testimony. In making that decision, you may consider a number of factors, including the following. 1. Was the witness able to see or hear or know the things about which that witness testified? 2. How well was the witness able to recall and describe those things? 3, what was the witness's manner while testifying? 4, did the witness have an interest in the outcome of this case or any bias or prejudice concerning any party or any matter involved in the case? 5, how reasonable was the witness's testimony considered in light of all the evidence in this case? And 6, was the witness's testimony contradicted by what that witness has said or done at another time, or by the testimony of other witnesses, or by other evidence? If you think that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely upon any of that witness's testimony. In deciding whether to believe a witness, keep in mind that people sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent lapse of memory or an intentional falsehood. And that may depend on whether that contradiction has to do with an important fact or with only a small detail. These are some of the factors you may consider in deciding whether to believe testimony. The weight of the evidence presented does not depend on the number of witnesses. It is the quality of the evidence, not the quantity of the evidence, that you must consider. Witness with a cooperation agreement. You have heard evidence that witnesses Jack Snyder and Tyler De Silva have signed a document entitled Cooperation Agreement with the state, terms of which are contained in States Exhibit 94 and 96 respectively. These agreements are permissible and the rules of court provide for their use. Although the state is permitted to present the testimony of someone who has signed a cooperation agreement in exchange for his testimony, you must examine the testimony of such a witness who provides evidence against a defendant with greater care and caution than the testimony of an ordinary witness. While examining the testimony of a witness who has signed a cooperation agreement and who has not been prosecuted with offenses for which the state has evidence, you should keep in mind that he may, in his own mind, be looking or hoping for some favorable treatment in the disposition of his own matters, and therefore may have such an interest in the outcome of this case that his testimony may have been colored by that fact. In considering the testimony of such a witness, you may consider whether there was any motive developed in the evidence for testifying falsely in inculpating the accused. The factors you may consider, among others, when evaluating the credibility of such a witness include the extent to which the witness's testimony is confirmed by other evidence, the specificity of the testimony, the extent to which the testimony contains details known only by the perpetrator of the alleged offense, the extent to which the details of the testimony could be obtained from a source other than the defendant, the circumstances under which the witness initially provided information supporting such testimony to law enforcement or a prosecutorial official, whether the witness has received a benefit or expects to receive a benefit, including immunity from prosecution, leniency in prosecution, leniency in sentencing, or personal advantage in exchange for testimony, and whether the witness has ever changed his testimony. Further, notwithstanding any language contained in Exhibits 94 and 96, the cooperation agreement signed by Jack Snyder and Tyler De Silva respectively, it is your exclusive role to determine the credibility and believability of that witness. In other words, you and you alone are to determine whether any evidence offered by Jack Snyder or Tyler De Silva is to be believed wholly, partly, or not at all, irrespective of any language in the cooperation agreement that may suggest otherwise. The determination as to whether the state has proven the elements of the crimes charged beyond a reasonable doubt rests solely with the jury after a careful examination of all the evidence presented. You should carefully scrutinize the testimony of Jack Snyder and Tyler De Silva before you accept it. However, you are not required to disbelieve a witness because he has signed a cooperation agreement. The law recognizes that there are many offenses that are of such character that the only persons capable of giving useful testimony are those who are themselves implicated in the crime. Like all other questions of credibility, this is a question for you to determine based on all the evidence presented to you. It is your duty to decide what credibility to give to any witness. Therefore, it is your duty to decide whether Jack Snyder and Tyler De Silva are to be believed wholly, partly, or not at all. Testimony of police officials. Police officials have testified in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall the police official's demeanor on the stand and manner of testifying and weigh and balance just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official just because he or she is a police official. Expert testimony. In this case, certain witnesses have taken the stand, given their qualifications, and testified as expert witnesses. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which the testimony relates. An expert is permitted not only to testify to facts that he or she personally observed, but also to state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion on them. An expert witness may state an opinion in response to a hypothetical question. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by an expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find the facts assumed were proved and whether the facts relied on in reaching the opinion were complete or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. In this case, you were provided expert testimony by the following witnesses: Dr. James Gill, Dr. Ryan Doss, P.A. Eric Black, and Dr. Roselle Crombie. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to you to assist you in your deliberations. No such testimony is binding upon you, and you may disregard the testimony, either in whole or in part. It is for you to consider the testimony with the other circumstances in the case and, using your best judgment, determine whether you will give any weight to it, and if so, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitle it to receive, and it must be considered by you, but it is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. Defendant's testimony. In this case, the defendant testified. An accused person having testified stands before you just like any other witness. He is entitled to the same considerations and must have his testimony tested and measured by you by the same factors and standards as you would judge the testimony of any other witness. You have no right to disregard the defendant's testimony or to disbelieve the defendant's testimony merely because he is accused of committing multiple crimes. Consider my earlier instruction on the general subject matter of credibility and apply them to the defendant's testimony. Proximate cause. Proximate cause does not necessarily mean the last act or cause or the act and point in time nearest to the death or injuries. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though his acts were not the immediate cause of the death or injuries. An act or omission to act is a proximate cause of the death or injuries when it substantially and materially contributes in a natural and continuous sequence, unbroken by an efficient intervening cause to the death or injuries. It is a cause without which the death or injuries would not have occurred. It is a predominating cause, a substantial factor from which the death or injuries follow as a natural, direct, and immediate consequence. It does not matter whether the particular kind of harm that results from the defendant's act be intended by the defendant. When the result is a foreseeable and natural result of the defendant's conduct, the law considers the chain of legal causation unbroken and holds the defendant criminally responsible. Specific intent. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. The concept of specific intent applies to count 1, murder and manslaughter in the first degree intentional as a lesser included offense. Count 2, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense. Count 3, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense. And count 4, assault in the second degree intentional. Recklessness. A person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when the defendant is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstance exists. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. The standard of conduct of a reasonable person in the same situation as the defendant is the doing of something that a reasonably prudent person would do under the circumstances, or omitting to do what a reasonably prudent person would not do under the circumstances. A gross deviation is a great or substantial deviation, not just a slight or moderate deviation. There must be a great or substantial difference between, on the one hand, the defendant's conduct in disregarding a substantial and unjustifiable risk, and on the other hand, what a reasonable person would have done under the circumstances. Whether a risk is substantial and unjustifiable is a question of fact for you to determine under all the circumstances. The concept of recklessness applies to count 1, manslaughter in the first degree, reckless as a lesser included offense. Count 2, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. Count 3, assault in the reckless degree, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. And count 4, assault in the second degree, reckless as a lesser included offense. Evidence of intent. What a person's intention was is usually a matter to be determined by inference. No person can testify that he or she looked into another's mind and saw therein a certain knowledge or a certain purpose or intention to do harm to another. Because direct evidence of the defendant's state of mind is rarely available, intent is generally proved by circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that infer what his or her intention was. To draw such an inference is the proper function of a jury, provided, of course, that the inference drawn complies with the standards for inferences as explained in connection with my instruction on circumstantial evidence. The inference is not a necessary one. You are not required to infer a particular intent from the defendant's conduct or statements, but it is an inference that you may draw if you find that it is reasonable and logical. I remind you again, the burden of proving intent beyond a reasonable doubt is on the state. Evidence of motive, or the lack of it, may also be considered by you in determining the issue of intent. You will refer to the court's instruction on motive below. Motive. The law does not require that the state in a criminal case prove a motive because it is not an element of a crime. It is not necessary for the state to prove what reason the defendant may have had for committing a crime charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of a defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. Consciousness of guilt. In any criminal trial, it is permissible for the state to show that conduct or statements made by a defendant after the time of the alleged offense may have been influenced by the criminal act. That is, the conduct or statements show a consciousness of guilt. For example, flight, when unexplained, may indicate consciousness of guilt if the facts and circumstances support it. Such acts, however, do not raise a presumption of guilt. If you find the evidence proved and also find that the acts were influenced by the criminal act and not by any other reason, you may but are not required to infer from this evidence that the defendant was acting from a guilty conscience. The state claims that the following conduct is evidence of consciousness of guilt: the defendant's disposing of the knife, the defendant's denial of his involvement in text messages to his girlfriend, and the defendant's flight from the jurisdiction of Florida. It is up to you, as judges of the facts, to decide whether the defendant's acts, if proved, reflect a consciousness of guilt, and to consider such in your deliberations in conformity with these instructions. Identification of the defendant. The state has the burden to not only prove every element of a crime, but also the identity of the defendant as the perpetrator of the crime. You must be satisfied beyond a reasonable doubt of the identity of the defendant as the one who committed the crime, or you must find the defendant not guilty. If you have a reasonable doubt as to the accuracy of the identification, you must find the defendant not guilty. Specific charges brought by the state. I will now turn to the specific offenses charged in this case. The substitute information in this case contains 4 counts against the defendant. In other words, the state charges the defendant with committing 4 separate offenses or crimes. You are to consider only the specific charges submitted to you and not concern yourself with how the information may have read when it was read to you at the start of trial. Please note, you will also be instructed to consider lesser included offenses where applicable. Additional instructions on your consideration of lesser included offenses will be provided further along in this charge as it concerns your deliberations on each count. The defendant is entitled to and must be given by you a separate and independent determination of whether he is guilty or not guilty as to each crime charged in each count, including lesser included offenses, if applicable, as instructed in accordance with this charge. Each of the 4 counts charged in the information, including lesser included offenses where applicable, sets forth a separate and distinct crime. The state is required to prove each element of each crime charged in a count, including lesser included offenses, beyond a reasonable doubt. Each crime charged under each count, including lesser included offenses where applicable, must be deliberated upon separately. Please note, the total number of counts charged in the information does not add to the strength of the state's case. You may find that some evidence applies to more than one count in the information or more than one crime under a count. The evidence, however, must be considered separately as to each element of each crime deliberated upon. Each count is a separate entity. You must consider each count separately, including lesser included offenses as instructed, and return a verdict, a separate verdict, for each count. This means that you may reach opposite verdicts on the 4 different counts. A decision on one count does not bind your decision on any other count. I have previously instructed you and herein reiterate. The substitute information is not evidence, it's merely a paper statement of the charges against the defendant on which the state proceeds to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt of the defendant from the substitute information. You will first deliberate on count 1 and then follow the order of deliberations as provided by the court in these instructions. So you're going to proceed to the court's instruction on count 1, murder. Statutory title, which is immediately below. 1, count 1, murder, Connecticut General Statutes, section 53A, 54A, subsection A. The state charges the defendant in count 1 with murder, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Valle, with intent to cause the death of one James McGrath, did stab and cause the death of the said James McGrath in violation of section 53A-54A, subsection A, the Connecticut General Statutes. The statute defining the offense of murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person. For you to find the defendant guilty of this charge, the state must prove the following two elements beyond a reasonable doubt. Element 1, intent to cause. The first element is that the defendant specifically intended to cause the death of James McGrath. There is no particular length of time necessary for the defendant to have formed the specific intent to kill James McGrath. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Murder is a specific intent crime, and you will refer to the court's earlier instruction on specific intent. The intent to cause death may be inferred from circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The type and number of wounds inflicted as well as the instrument used may be considered as evidence of the perpetrator's intent, and from such evidence an inference may be drawn that there was an intent to cause death. Any inference that may be drawn from the nature of the instrumentality used and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with my previous instructions. Such inferences are not necessary, but they are inferences you may draw if you find they are reasonable and logical and in accordance with my instructions on circumstantial evidence. Declarations and conduct of the accused before or after the infliction of wounds may be considered if you find they tend to show the defendant's intent. This inference is not a necessary one, that is, you are not required to infer intent from the defendant's alleged conduct, but it is an inference you may draw if you find it reasonable and logical and in accordance with my instructions on circumstantial evidence. Element 2, cause of death. Second element is that the defendant, acting with the intent to cause the death of James McGrath, caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of James McGrath's death. I'm going to refer to the court's earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, for the crime of murder, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause the death of James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the offense of murder, you shall find the defendant not guilty of the crime of murder and shall then next move on to consider lesser included offenses to murder below in the manner and order therein instructed therein. Proceed to the court's instruction on lesser included offenses to murder below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of murder, you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense and defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved beyond a reasonable doubt one of the statutory disqualifications, you shall reject the defenses and find the defendant guilty of murder in violation of Connecticut General Statute, Section 53A-54A, subsection A at count 1. Please note, the state in proving statutory disqualifications has to prove the statutory disqualifications also beyond a reasonable doubt. This will end your deliberations on count 1. You will not deliberate lesser included offenses to murder. You will now deliberate on count 2. We'll skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault with first degree intentional below. If, however, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, that on the strength of the defenses alone, you must find the defendant not guilty of murder at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations on count 1. You will now deliberate on lesser included offenses to murder. You will now deliberate on count 2. You will skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault in the first degree intentional below. Lesser included offenses to murder. In accordance with the court's previous instructions, you will consider lesser included offenses to murder under this section if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of murder and therefore have found the defendant not guilty of murder. The defendant at count 1, the substitute information, is specifically charged with the crime of murder. The offense of murder under our penal code is such that it may include the elements of the crimes of manslaughter in the first degree intentional and manslaughter in the first degree reckless. This brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to murder in the order and under the circumstances set forth herein. The fact that I am instructing you on lesser included offenses should not be interpreted by you that I believe the evidence proved the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case, and you must determine whether the defendant is guilty beyond a reasonable doubt of murder at count 1 or is guilty of any respective lesser included offense. You will first consider the lesser included offense of manslaughter in the first degree intentional. Connecticut General Statute, Section 53A, 55A1, directly below at subsection A. We proceed to the court's instruction. Subsection A, manslaughter in the first degree intentional, the statutory reference directly below. Subsection A, manslaughter in the first degree intentional. Connecticut General Statute, Section 53A, 55A1. Statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when, with intent to cause serious physical injury to another person, he causes the death of such person. For the defendant to be found guilty of this charge, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant specifically intended to cause serious physical injury to another person. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. You will note that the basis of the charge under this statute is not that the defendant intended to kill, but that he intended to inflict serious physical injury. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Refer to the court's earlier instruction on specific intent at 15. The intent to cause serious physical injury may be inferred from circumstantial evidence. Refer to the court's earlier instruction on evidence of intent at 17. Element 2, cause death. The second element is that the defendant, acting with the intent to cause serious physical injury to a person, caused the death of a person. This means that the defendant's conduct was the proximate cause of the decedent's death. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause serious physical injury to James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, you shall find the defendant not guilty of manslaughter in the first degree intentional at count 1, and you shall next consider the lesser included offense of manslaughter in the first degree reckless. Proceed to the court's instruction B, manslaughter in the first degree reckless, Connecticut General Statute, Section 53A, 55A3 below. If, however, you unanimously find the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree intentional, you shall not consider any additional lesser included offense. You shall, however, consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree, intentional violation of Connecticut General Statute, Section 53A, 55A1 at count 1. This will end your deliberations at count 1. You will next deliberate on count 2. Proceed to the court's instruction. Count 2, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree intentional in violation of Connecticut General Statutes 53A, 55A1 at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 1. You will not consider any additional lesser included offenses to murder. You shall skip over the court's instructions at subsection B below and next deliberate on count 2. B, manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3. You will deliberate on this lesser included offense to murder if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of murder, and therefore you have found the defendant not guilty of murder. And further, you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, and therefore you have found the defendant not guilty of manslaughter in the first degree intentional. The statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. For the defendant to be found guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a grave risk of death. The first element is that the defendant engaged in conduct that created a grave risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant's conduct demonstrated an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, cause death. The fourth element is that the defendant's conduct caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of the decedent's death. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a grave risk of death. 2, the defendant acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree reckless, you shall find the defendant not guilty of manslaughter in the first degree reckless to count 1. This ends your deliberations at count 1. You shall next move on to deliberate on count 2. And proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statute 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, You shall reject the defenses and find the defendant guilty of manslaughter in the first degree, reckless, in violation of Connecticut General Statutes 53A, 55A3 at count 1. This will end your deliberations at count 1. You shall move on to deliberate on count 2. Proceed to the court's instruction on count 2, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, after considering the defenses, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree reckless at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 1. You shall move on to deliberate on count 2. You'll proceed to my instruction on count 2, assault in the first degree intentional, Connecticut General Statute, section 53A-59A1 below. All right, I'm going to give you a few minutes to stand up and stretch. We're going to take a short break. So I'm going to take a 10-minute break right now, give you some time to go back into the deliberations. And again, you can't talk. I'm in the middle of the charge. You're not allowed to deliberate yet. Court stands in brief recess. We're going to be back in 10 minutes.
Court is now back in session. The Honorable Judge Griffin now presiding. Good afternoon, Your Honor.
Good afternoon, Judge.
Are you maybe seated? Thank you.
Votes are back in session. Your Honor, just one on one.
We'll wait on, thank you.
I'll set, Your Honor.
Thank you. Okay. All right, welcome back, ladies and gentlemen of the jury. I want to thank you for your patience during the reading of these instructions. I know that it's a long time to be seated, so thank you for your attention. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, thank you so much. I'm going to continue. So I'll be continuing with count 2. Assault in the first degree intentional, Connecticut General Statutes 53A, 59A1. State charges the defendant at count 2 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant with intent to cause serious physical injury to one Ryan Hines did cause serious physical injury to the said Ryan Hines with a dangerous instrument, to wit, a knife, in violation of section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when, with intent to cause serious physical injury to another person, he causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. The first element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. You refer to the court's earlier instruction on specific intent. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by a statute as physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss of impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Ryan Hines. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that Ryan Hines was seriously injured as a result of the actions of the defendant. It does not matter whether Ryan Hines was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person and that he in fact caused serious physical injury to that person or to some other person. Element 3, with a dangerous instrument. Third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it was used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use,
may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstance. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person, the defendant did cause serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 2, and shall move on to consider lesser included offenses to assault in the first degree intentional below, in the manner and order prescribed therein. You will proceed to the court's instruction on lesser included offenses to assault in the first degree intentional under the section below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 23. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, then you shall reject the defenses and find the defendant guilty of assault in first degree intentional in violation of Connecticut General Statutes 53A, 59A1 at count 2. This will end your deliberations at count 2. You will not consider lesser included offenses. You will move on to deliberate count 3. So you'll skip over lesser included offenses to assault in the first degree intentional below and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defense alone, you shall find the defendant not guilty of assault in the first degree intentional at count 2. Even though you have found the elements of the crime of assault in the first degree intentional proved beyond a reasonable doubt. This will end your deliberations as to count 2. You shall then move on to deliberate count 3. You will skip the court's instruction on lesser included offenses to assault in the first degree intentional below and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 2 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional at count 2. The defendant at count 2 of information is specifically charged with the crime of assault in the first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. This brings into play a rule of law known as lesser included offenses at count 2 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 2 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 2 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offenses. You, the jury, are the sole judges of the facts of this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below. Proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 directly below. A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person, and thereby causes serious physical injury to another person. For you to find the defendant guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result of circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused serious physical injury. The fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death, 2, he acted recklessly, 3, he acted under circumstances evincing an extreme indifference to human life, and 4, he caused serious physical injury to Ryan Hines. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 2, and you shall then consider the lesser included offense of assault in the second degree intentional. You'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 at count 2. This will end your deliberations at count 2. You shall not consider any other lesser included offense at count 2. You will skip the court's instructions in subsections B and C below and shall next move on to deliberate on count 3. We'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall not consider any other lesser included defenses at count 2, included offenses at count 2. You will skip the court's instructions at subsections B and C below. You will move on to deliberate on count 3. You'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Still under lesser included offenses, B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 2. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove beyond a reasonable doubt 3 elements. Element 1, intent to cause physical injury. The first element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such a result. You will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Element 2, caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. You will refer to the court's previous instruction on proximate cause at 14. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or to some other person. Element 3, with a dangerous instrument. Third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or a serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person. 2, the defendant did cause physical injury to Ryan Hines. And 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 2, and you shall then consider the lesser included offense of assault in the second degree reckless. You'll proceed to my instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A 60A3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. You will refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statutes 53A 60A2 at count 2. This will end your deliberations at count 2. You shall not deliberate on any other lesser included offenses. You shall move on to deliberate count 3. Proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A 59A A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, and on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall not consider any other lesser included offenses at count 2, you shall then move on to deliberate count 3. You will skip subsection C below and proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Still on lesser included defenses, C, assault in second degree reckless, Connecticut General Statute 53A, 68.3. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the second degree intentional, and therefore have found the defendant not guilty of assault in the second degree intentional. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that this defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. Refer to my previous instruction on recklessness at 16. Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing the serious physical injury to another. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it is used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 2. This will end your deliberations at count 2. You shall next move on to deliberate on count 3. Proceed to the court's instruction. Count 3, assault in the first degree intentional, Connecticut General Statute, section 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statute, section 53A, 68.3 at count 2. This will end your deliberations on count 2, and you shall move on to deliberate on count 3. You'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall move on to deliberate at count 3. Proceed to the court's instructions. Count 3, assault in the first degree intentional. Connecticut General Statutes 53A, 59A1 below. Count 3, assault in the first degree intentional. Connecticut General Statutes 53A, 59A1. The state charges the defendant in count 3 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause serious physical injury to one Thomas Connery Jr., did cause serious physical injury to the said Thomas Connery Jr. with a dangerous instrument, to wit a knife, in violation of section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when with intent to cause serious physical injury to another person. He causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such a result. Refer to my earlier instruction on specific intent at 15. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Thomas Connery Jr. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously injured as a result of the actions of the defendant. It does not matter whether Thomas Connery Jr. was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person and that he in fact caused serious physical injury to that person or to some other person. And element 3, with a dangerous weapon or instrument. The third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument, if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death, the state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person. 2, the defendant did cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. I'm sorry. I'm going to strike the in summary that I just gave. Let me just read through that again. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. And 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 3, and you shall next consider the lesser included offenses, starting with assault in the first degree reckless, proceed to the court's instruction on lesser included offenses to assault in the first degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree intentional in violation of Connecticut General Statutes 53A-59A1 at count 3. This will enter deliberations at count 3. You will not consider lesser included offenses. You will move on to deliberate on count 4. Skip the court's instruction below on lesser included offenses to assault in the first degree intentional and proceed directly to the court's instructions on count 4, assault in the second degree intentional, Connecticut General Statutes 53A-68-2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you shall find the defendant not guilty of assault in the first degree intentional at count 3, even though you have found the elements of the crime of assault in the first degree intentional proved beyond a reasonable doubt. This will end your deliberations as to count 3. You will not consider lesser included offenses. You shall move on to deliberate on count 4. Skip the court's instruction below on lesser included offenses to assault in first degree intentional and proceed directly to the court's instruction on count 4, assault in second degree intentional, Connecticut General Statutes 53A-68-2 below. All right, I am going to give you another 5 minutes just to stand up, take a break, and take a 5-minute recess because I know this is long, okay? Court's going to stand in recess for 5 minutes again. Please do not discuss the case. Court stands in recess.
All right, recess.
I appreciate your focusing your attention. I know this is not easy. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right. I'm going to talk to you now about lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 3 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional at count 3. The defendant at count 3 of the substitute information is specifically charged with the crime of assault in the first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. Similar to count 2, this brings into play the rule of law known as lesser included offenses at count 3 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 3 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 3 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below its subsection A. You'll proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 59A3 directly below. A, assault in the first degree reckless, 53A, 59A3. Statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of the charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstance when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 60. Element 3, extreme indifference to human life. Third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused serious physical injury. Fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as the result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury. It is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death. 2, he acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, he caused serious physical injuries to Thomas Connery Jr. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 3, and you shall then consider the lesser included offense of assault in the second degree intentional. We'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A2 below. 53A-60A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, Then you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory exceptions beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 of count 3, at count 3. This will end your deliberations at count 3. You will not consider any additional lesser included offenses under count 3. You shall move on to deliberate count 4. You'll skip subsections B and C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You will not consider any other lesser included offenses under count 3. You shall move on to deliberate on count 4, skip subsections B and C below, and proceed directly to the court's instruction on count 4, assault in second degree intentional, Connecticut General Statutes 53A, 60A2 below. B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found that the defendant is not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 3. The statute defining this offense reads in pertinent part as follows: a person is guilty of assault in the second degree, but with intent to cause physical injury to another person, he causes such injury to such person by means of a deadly weapon or a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. You will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injury. You will refer to the court's earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to the person or to some other person. Element 3, with a dangerous weapon. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Thomas Connery Jr., and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed, I'm sorry. Yes, if you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 3. And you shall then consider the lesser included offenses of assault in the second degree reckless. We'll proceed to the court's instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A 60A3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claim of self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statutes 53A 61-2 at count 3. This will end your deliberations at count 3. You shall not deliberate on any lesser included offenses. You shall move on to deliberate count 4. We'll skip subsection C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 60A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You shall not consider any other lesser included offenses, and instead shall move on to deliberate on count 4. You will skip subsection 3 below and proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes, section 53A 60A2 below. C, assault in the second degree reckless, section 53A 60A3. The statute defining this offense reads in pertinent part as follows: a person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. I'll refer to the court's previous instruction on recklessness at 16. Element 2, caused serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the defendant's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical conditional pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing the serious physical injury to another. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means serious physical injury which creates a substantial risk of death or which causes serious disfigurement, creates a substantial risk of death or which causes, creates backups. I'm going to redefine serious physical injury for you, so strike that part of my charge. Under dangerous instrument, element 3. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used, any article or substance without limitation, and even though harmless under normal use, may be found by you to be dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Thomas Connery Jr., and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 3. This will end your deliberations at count 3. You shall next move on to deliberate on count 4. Proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 60A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes 53A 60A3 at count 3. This will end your deliberations at count 3, and you shall then next move on to deliberate count 4. You'll proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes section 53A 60A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3, and you shall move on to deliberate on count 4. So you will proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 60A2, immediately below. All right, ladies and gentlemen of the jury, it has been a long day of sitting, and we are about a little over, I would say, 3/4 of the way done with my charge. However, it is 4:30. So I am going to go ahead and I am going to adjourn for the day. So what that means is, let me go over this again. You have heard all the evidence, you've heard closing arguments, you've heard part of the jury charge, part of the court's instructions to you that apply in this case. You have not heard all of those instructions, nor have you been told to engage in deliberations. You still remain under the obligation of your oath and your journal of conduct rules still need to be abided by. So please do not discuss this case. You cannot even discuss it with one another. Please, it's a long weekend. We're not here tomorrow. Tomorrow's July 4th. It is a holiday. So I know this is a little bit longer than I had initially anticipated. Hopefully this is not too much of an inconvenience, and I do apologize to the jury. But July 4th is a holiday. We will next convene on this case Monday, July 7th. So you will come back on Monday, July 7th. I will finish up the jury charge at that time in the morning. So we'll get on the record right at 10, and then you will start your deliberations. All right, so no discussing the case. Again, I can't impress upon you the extent to which this case is being covered in the news, social media, and other outlets. Please do your best to avoid the news, social media, and any other outlets where something like this may be posted. I mean, I can't control your actions, but I am going to ask you, please take this case seriously and your duties relevant to your conduct seriously. Have a fantastic holiday. Have a nice long weekend, and we will see you back here on Monday for the continuation of the trial. Thank you. Court stands adjourned.